No mentioning for inclusion. Sorry.
Your lordship,
You will call
Point
resolutions,
order,
not to attend
230
resolutions, and will include matters. Sorry, no inclusion.
and the police authority did not pay heed with regard to this matter.
Wait
Your
for some time.
lordship orders was violated.
For some time, you cannot shout your way into court. We are not taking up any inclusion today. Sorry.
But you both
permitted
you-
to mention
your
matters
Know your limits, please. We are saying no. Will not take any mentioning. Please call the list.
for filing the review application without certified.
No, refused.
What can I do now? What
Written
can I-
notes were to be filed.
This was for filing of the note right now.
Yes, yes.
Kindly give me lot just half an hour more. It's ready. It's ready.
When a counsel are not ready with the written notes of arguments at the time of call, let the matter stand adjourned for the day. Next.
My lord, what can I do now?
This is not a inquiry office, please. Please.
My lord, in this matter, I am appealing for the respondent number 1. Item number
The order date has been misprinted. In the order dated March 5, 2025, 2026, comma, the date of the order was erroneously mentioned as March 5, 2025. Full stop. Let the said order be deemed to stand dated as March 5, 2026.
My lord, this can 3 and can 4 is my lord, my recalling application and my limitations.
This is only appealing for this. Yes.
My lord, item number 3, I appear for the respondent.
Same mistake. The date has been erroneously mentioned.
Yes,
Yes.
my lord.
Same order.
Should be 26. My lord.
Okay. Same order. He করেছে এগুলো? Ashraf.
I am for the petition.
Same order. Yes. Date correction.
Grateful.
5 is.
My lord, I appear for the appellant.
Yes.
My lord, 5, 6 and 7, it was the
Together.
common judgment.
কিরকম হয়ে গেল?
So lordship, kindly take 7. That was the lead matter.
7 is FMA number. Please give us the number.
Yes.
7 at
288.
the ring.
My lord, lordship may not be required to see anything. I have made a 2-page list, just
Thank
the
Yes.
list of kindly take. Other set copy. এটা এটা।
ছোট মামলা চলছে আমাদের।
কি হচ্ছে? সরাবো।
Yes.
My lord, this matter involves, according to my understanding, one of the very fundamental things in the higher educations. It's like some parents, they have money.
Mr. Dhar, do we have determination otherwise?
Yes, it is assigned.
Oh,
Because the honorable single judge who dismissed the writ petitions
was a part of the bench.
part of the honorable division bench, so that's why it
This
was,
has been assigned to it.
yes,
Assignment.
it is assigned.
Oh,
It is assigned.
please carry on.
My lord, once there is a for engineering,
Yes.
there is a joint entrance
Sir,
examination.
please leave. Please leave the court. Please leave the court.
It means আপনার mentioning সময় না থাকে।
You don't deserve your gown.
Your lordship.
Please leave the court.
Such a nature that
Thank you very much. Please leave the court.
My lord,
Wait, Mr. Dhar, give us half a minute. We have a zero tolerance for nuisance, please.
on former occasion.
Arrange your papers outside, please. We said arrange your papers outside.
কাগজগুলো বাইরে।
Yes, Mr. Dhar, please carry on.
My lord, every parents,
Yes.
they aspire that their son or the daughter, they would be doing better than them. That's the now every aspirations, my lord, it is always scuttled by variety of factors. One such factors is the amount of money. For an example, my son or my daughter might be excellent, but in this case, for an example, it's a joint entrance examinations. There is a rank. Now, once there is a rank, then there is a thing called the counseling. Counseling is fundamentally a number of choices are given. I get to know how much money in which college and whether suiting to my rank. If I have a higher rank, I get A to Z. If I have a lower rank, my choice becomes less. So this counseling whole concept is based on rank, also whether the parents I would be able to afford. If I give a very clear example in our, like Zindal seems to be one of the very fine law colleges, but even if one candidate is selected, but I might see that no, I won't be able to afford for this entire course. So
You'll
therefore,
go for the next option.
I will
You
go
have
for the
to.
next one. But that's a very, very concept which is a very general. Now that has been translated also in reality in two forms by various judgment of the Honorable Supreme Court and also by statutory regulations. The pinpointing part of the regulation is not that every institution must have a must cater to the poor or must have a one. Pinpointing part, there has to be a transparency. Before admissions, one must know how much amount of money, because a large number of these engineering students, they take loan. In the midst, like I get my son or the daughter admitted at X amount of money for the 4-year or 5-year course. In the meantime, there should not be a hike. This is the crack.
In the meantime, between
There should not be a hike.
meantime means before you get to know and
There
before
are
you are admitted.
semesters.
Throughout your course, you are saying it should not be high.
I'm saying that
Hmm.
in the entire course, the hiking whole concept, the hiking goes as per the statute as a structure. There is no problem in hiking, but that hiking goes in a sense once there is a structure called first semester, let's say X amount, second semester X plus one.
All the semester amounts are informed at the outset.
Yes.
So you say throughout the course
Yes.
for that person,
Yes.
there should not be a hike in any of the semesters.
Yes. That is my
Premised on the principle of estoppel also.
yes.
Yes.
That once you get to know that this is your fee structure and give that in clarity prior to counseling, and thereafter I take the admissions. Now after first semester is over, because my lord, I don't have the money.
You
There
have
are
to
many
arrange for
cases.
annual loans.
So either law must give them that power that the college authorities, the engineering colleges, they can enhance no matter what they like, or yes, you can enhance, because even that enhanced power has been taken away from them. Now there, as per the judgment of the Honorable Supreme Court and also the specific statutory regulations, there has to be a committee.
Even for private colleges.
Even for all private colleges, because it was that scenario was not there, sentiment was there. That's why I began with the sentiment, but that sentiment has been translated into law as well as, my lord, the judgments of the Honorable Supreme Court. Now, Lordships, kindly take this 2-page list of dates.
Yes.
Well, like April, that was the joint entrance examination was held. It's not much relevant, but just it happened. Now, result was in May.
Yes.
Now, July to August, my lord, the counseling process, if I can just read: online registrations, payment of counseling fee, choice filling by candidates, that's a selecting college and branch preference, then centralized seat allotment by merit cum preference, then seat acceptance and fee payment online, physical reporting to allotted college, document verifications, and then admission completed. My lord, I have made it bold because that would be one of the most important parts. What is an admission? So admission is done.
Who are before us? The students.
Students. Well, there is a good number of, in fact, because it may have a far-reaching consequence, the Association of the Self-Finance Colleges, they also made an application for addition of party. They say that then we will be affected. That was allowed.
Yes.
That, and they were also hard. Now, serial number 4
So Bhattacharya, you are appearing for whom? You are appearing for whom?
for the engineering college,
I'm waiting for the college.
Dr. B.C. Roy Engineering College. This is
Please take it. Yes.
my lord, from July to September. My lord, this serial number 4. All the appellants, they took admission in BTech, and this is a 4-year course, 23 to 27 batch at Dr. B.C. Roy Engineering College, Durgapur. Now, fees were deposited at the rate published by the college during the admission process. Well, I will show that later on. Now, admission was based on the fee structure at 74. Now, if if your lordships kindly come to 74 at once.
Yes.
Well, that is the fee structure.
Right.
Lordship, thereafter we'll see there is entire 23 to 27. That's the entire batch. So, and then Lordship is also see this fee structure was not for first semester or second semester. Kindly see, my lord, the first column,
Enter.
first semester,
Up to 8th semester.
and admission fee. Lordship will find that the admission was only in the first semester. Thereafter, there is no. So it's not an every semester I have to take a separate admissions. That 5,000, 1, 2, 3, 6
And fee is not mentioned. Yes.
is mentioned.
Right.
It is mentioned because
Okay.
it's at the beginning. Now, I intended to say that admission is not a process which happens after every semester. It's once, it's for entirety. Now, there is one part which has,
Some colleges they are taken every time that was raised in the parliament also probably
my
recently.
lord, there in if any college, if they do so, they are violating the clear provisions of the law.
The law
I'm
is
not,
already
not
there.
touching there is a clear-cut law, and
We'll come to that.
yes, only point is what is the interpretation. In fact, I have brought most of the times I have spent on Oxford English Dictionary what is the meaning of the word entire, because when I saw entire is something, nobody goes to dictionary.
Entire has different meanings.
Now, entire doesn't have a different meaning, but to my understanding,
shades of it.
the honorable single judge, with all respect, has given a meaning to the word entire, which is
Restricted.
completely different to general understanding and meaning of the word entire.
All right.
Now, this 74 has has also 75, which has been which my learned friend would be definitely arguing against me, but to my understanding it is not against me, but I should show that apparent negative part. Kindly come to my lord 75. 75, my lord, little bottom there is a bold portion. Fee structure is subject to change from time to time as per government decision.
This is a full-fledged government college.
Sorry,
Full-fledged government college.
no, this is not a not at all government college. This is, my lord, they need a recognitions, and there is a statutory authority, AICT, they regulate it.
But the
And
government has a control.
entirely, because they cannot even ask for 1 paise unless that committee they prescribe for them. But that part and jurisdiction, that part, that is because this has been
Self-financed.
yeah, it is the nomenclature is they finance themselves, which means they finance from, of course, from
Their own incomes. Yes.
yes. Here it is fee structure is subject to change from time to time.
Yes.
I have no quarrel with it, but the other meaning of the English word would be what is structure. Now, Lordship, kindly come to this list of dates. So 16th of by 16th of September, serial number 4, all our admissions were completed on the basis of page 74. That was because when we did, my lord, counseling, we saw these are the choices. So then, of course, we said to our parents that these are the choices I have, then affordability of my parents. Based on that, I selected this because I know this is the total expenditure which my parents would be able to afford it. So entire admission is over by 16th of September. Then first semester class started, my lord, in September. Now, before I show serial number 6, just for, sorry. My lord, once the entire admission process is completed, since we are under the control of the university, this is Maulana Abul Kalam Azad University. Now, registrations has to be done by the university. So registrations, like when we also studied law, my lord, there was an admissions and subsequently there was registration by the Calcutta University. So one of the purposes of giving little more importance to this, that registration always happens after admission is over. Well, now serial number 6, that our class started in September, then October, university registration started. So, well, I've just registration happens only after admission is finalized. Now, Malat, 16th of October, fee was hiked for the students.
To be admitted was in that circular.
For the students who would be admitted, may I say 82.
Yes, that is also important.
Yes, that is. This is the notification by the
If they
government.
go by their own circular, then you need not argue much. Yes.
Malat, in fact, my point is, I am covered by it.
That was what we were
Unless it is
thinking. Yes.
straight so against me. And this is the reflections of the statute. Well, kindly take third paragraph.
Yes.
Accordingly, the tuition fees and other fees for the students, well, this thereafter
Admitted is there.
to be admitted.
All right.
Now, this to be admitted is 94 regulations. Is not there like discretion, it's a mandate. Well, this is the 1994 statutory regulations under which this professional college, they have to have their fees. It's not that their own choice. There is a petition is there, but separately it's better. Well, kindly straightway come to it's 7-7.
7-7, yes.
7-7, my lord, this is bottom left hand side.
In advance.
No, it is a professional. It starts with a professional.
In the middle, in advance. Shall send intimation.
Yes, Lordship was.
Obviously, yes.
It is always. May I read, my lord, full, slowly. A professional college shall send intimation to competent authority in advance. The fees chargeable
For this entire.
for the entire course. Well, entire
Otherwise, quite obvious. I mean, let us see. Yes.
In fact, that's the reason I said that was precisely the reason I spend more time with dictionary rather than the law and other things.
Spend the entire time in entire.
Yes. Now, the entire course, kindly see the wordings. Each of this is helping the other one. Commencing from the academic year for which admission shall be made.
Yes.
The total, again the word total fee shall be divided into the number of years. That's why that's a chart having entirety. Or as the case may be, the number of semesters of study for a course. In the first instance, fees only for the first year or semester shall be collected. But the next is not relevant.
So then, therefore, structure has to be read in this context, you are saying. That if it says that the total fees and it is qualified by shall be divided into number of years and etc. So the total fee has to cover the entirety of the years.
Now, Lordships, kindly, for the moment, think of that these provisions are not there for the moment.
Yes.
There is no such law. Even otherwise, if I can use the word, a talented or someone who has a better rank, he or she chooses a lesser college. That is only because whether my parents would be able to afford it or not. Even if I say it is not there, there is no such provisions. I would be seeking your lordships that I am not saying that the college or the authorities cannot hike.
Definitely they can, yes.
They can, even the very next year. But there is a frozen thing. Like once they enter, once I choose, thereafter.
But that's academic, what should you say, the entire course,
Yes.
that course, it's crystallized.
My lord, not only in engineering, now because the higher education has become quite costly, unlike the other time.
Yes.
It's quite costly. Now the majority parents, they actually take loan.
Yes.
So now in the midst, when we take the loan on the basis of page 74 here. Entire structure, this is the total. So therefore, now when I see that I won't be able to afford it, I come to the next college.
So that entitlement at page 75 is subject to this, you are saying. You
Yes.
can do it for the next year.
Yes, I say that
Anytime or time to time, we'll apply to the
anytime.
next
I
year.
have no difficulty, but there are two restrictions in my understanding. One restriction is that it will apply to the students who will take admissions, because then it will be a transparency for them.
These admission dates are universal across the board,
Almost.
more or less.
Almost.
More or less, because the session is
yes,
has to
because
start.
otherwise that counseling process, because joint entrance examination happens,
Counseling is,
is
done
central,
compulsively.
across the board. So
So
therefore,
therefore, if I come to know, and if I say that my ward will go somewhere else,
yes,
he or she wouldn't have the option even.
correct. It's not that I take an admission.
Cannot go to a lesser.
No, I can. So I have to take a call on the rank as well as the affordability, both. Now, after they completed,
You say it's frozen after counseling.
no, I say it is
Before
it is
counseling.
frozen after I give the benefit of admission date. I say that you published on which basis I have seen it, and thereafter once in fact it could have been that Lordship has said that that is even more ideal, that the day counseling happens, that's the day it should be frozen. But I'm not required to go there because my admission date is pre that hike. So therefore, I take this that once I'm admitted, once I'm in,
Yes.
the structure that was shown to me.
Has to continue.
Now, the view of the honorable judge was when the writ petition was filed, because after we completed the first semesters, what happened that there was a hike.
All the students are.
But there is in fact, today also examinations, and in last one examinations, they did not allow about 200, about 300. About, because when there are three matters, the matter I am appearing, there are 70 students, and the other matters, other students. It is identical. It was a common judgment. Interim order was passed on the very first day when the writ petition was. Then all along till the disposal, there was an interim order, but there was a pendency. So one semester has gone. It was another semester. So
order not giving effect to the hike.
Yes, so that you pay on the basis of that initial, that structure, we have paid that, not on the basis of the hiked one. But today's urgency and situation is, we are in the 6th semester. Now, they have not even allowed, from 13 the exam has started. They have not allowed us. Now, because they have not allowed, the problem is, in the placement, it will be a marking as if we get a backlog. That means that stamp, unless they hold an examination for us, I mean, examination still there, even from today from 2 o'clock and up to 25th. If Lordships protects us, then we would be able to sit in the examinations today and up to 25th. But there is one exam, one or two, 13th? Three exams, they already took place because
13, 14, 14.
so two dates examinations already happened. They and what happened? They said that unless you pay because it was quite a good amount of money starting from the first semester hiking. Now, some of the students whose parents were able to pay the money, they paid the money so that their son and daughter can sit in the examinations. And most of them, they have not been able to. They are before your Lordships. Now, the view of the Honorable Single Judge was, first, there was an interim order, all along we enjoyed till the disposal. View of the Honorable Single Judge was that the word entire in the statute, that is overridden by the prospectus. This no, it's not 75. Yes, that is overridden by 75, subject to change from time to time. Now, there are in my respectful submissions, there are 2-3 areas on which basis, my lord, I would be resting my case. My first respectful submission is that even if there is no such mandate, there is a requirement of transparency. It cannot be in the manner that anytime, every time, because this is the regulated.
There should be a certainty about it.
There should be certainty. Otherwise, if there would be a devastating effect. So there has to be certainty. Now that's my submissions in situations when there is a zero regulations in my favor. But on the part of the regulations, and also there are a couple of judgments, my submission is that there is a difference between a structure. In fact, my lord, I gave that a precise example before the Honorable Single Judge also. I said that when we say about structure of a building, we don't refer to a first floor or the second floor. Structure means in total. So when it is a structure, so there is a movement of structure. It is not that you movement of a first floor or the second floor, unless it is specifically allowed. Now my lord, in my favor, if lordship may kindly, I know this sounds apparently why I'm first is from the Oxford and then the blacks. Oxford hand. The statutory word entire, this is in the Oxford. Well, this is
Entails is underlined.
well, what happened that when I was in college, I was learning English for several
But you
years.
underlined this.
No, there is a surprising thing about this dictionary of mine. I think I discovered it after about 10 years because I never, I had the habit of seeing the dictionary. One day I discovered there is not even a single page I have not marked. And that happened from my first year to fifth year. Because after fifth year, when I joined, but I had a habit
Marking other things,
and I didn't know
other
because
papers.
so now every time I go whatever word, I see at least one page something marking. It has a good memory. Like things happen very slowly if we continue in that fashion. Now, Malad, kindly see the entire. It's a whole. It's complete. And then number 4, in one piece. Rest of the words are not relevant here. Now, in the kindly take now the blacks. It is page number 649. It's whole on a top right hand side. Whole, complete, all its parts, not divisible into parts. Now, the other word which their power on structure, again, my lord, first the Oxford structure. Left hand side, top. Here, any construction, productions, or piece of work artificially built up. In fact, before the Honorable Single Judge, my lord, I made these submissions, but then I did not place the Oxford or the blacks.
Structure says a whole constructed unit here.
Yes, yes. So I am only on the point that any construction, productions, or piece of work. Sorry. Oh, sorry. I was sorry, my lord. I was reading the.
You were reading from Black.
Yes.
Yes.
Sorry. It's a whole constructed unit, especially a building, and then 2, a set of interconnecting parts of any complex. So basically, it is what you understand without seeing the any dictionary. It's complete. And then, my lord, in the blacks structure. Any construction, production, or piece of work artificially built up or composed of parts purposefully joined together. And then a building is a structure. So an example was given. In fact, this example, I specifically, that was the example, and that was also the Honorable Single Judge has referred. Sorry?
Also number 2.
That's not necessary. This is on the what should be the exact meaning of the. Now, if I can request your lordships to take the reasons that the Honorable Single Judge has taken. Somewhat, only there are large, judgments part are there. I will be showing the judgments after I show, according to me, why the Honorable Single Judge was possibly not correct. Now, kindly straightway come to paragraph 46. Therefore, the fee structure has not been treated as indivisible either under the 1994 regulations or under the notification dated 16/8/23. That 16/8/23 is to be admitted, that notification. Rather, it has been divided according to the number of years, or as the case may be, the number of semesters of study for the purpose. What possibly the Honorable Single Judge has, Lordship has seen the table. Table has first semester, second semester, everything is there. Now, because it is there, I think this interpretation has come. So, structure has to be made up of something. So, now then 47, Mr. Daw had emphasis on the expressions to be admitted to content that the use of such words indicates that the notification is intended to operate prospectively. Mr. Chakraborty, however, refuted his contention, asserted that the expression to be admitted was used to qualify the category of students and not to indicate the time from which the notification would take effect. Well, this goes, in my understanding, in the very understanding of English also is to be admitted. Then 48, in the present case, the academic year commenced in July 23 with the first semester running from July 23 to December 23. Academic year 23-24 comprises 3 semesters, namely such and such, such and such, such and such. Thus, it is evident that despite being aware that the academic year had already commenced such and such, the effect of the notification dated 16/10/23 was consciously given from the date of its issuance and from the academic year 23-24. Undoubtedly, the use of the expression to be admitted gives rise to a degree of ambiguity. However, it is a well-settled principle that where a notification expressly specifies the date from which it is to take effect, such explicit stipulation prevails over and conflicting or ambiguous language appearing elsewhere in the notification. In the backdrop, the intention discernible from the notification is manifestly clear that the notification dated 16th October was intended to take effect from the date of its issuance and for the academic year 23-24. And the purpose of the notification was to determine the fee structure from academic year.
Mr. Dhar, is there any scope of midterm admissions in these courses? Can one be admitted midterm?
Well, I have a direct answer, but instead of giving answer, I will show 74 and then I will give my answer. Kindly come to 74. Well, that was my question in the conference. I wanted to know. Kindly come to 74. Had there been, then the admission fee under first semester, there would.
One admission. All right. Yes.
Yes, my lord. I was on the.
So coming back to page
Yes.
para 49.
Yes, 49. My lord, 49, kindly come to 50. Where the Honorable Single Judge felt that it's a prospectus which overrides the statutory. Now 50, a prospectus or brochure ordinarily operates as a contractual arrangement. Well, that the Honorable Judge was referring to that part of this prospectus where it also refers structure. But it can be hiked, subject to. Upon enrollment, a student is deemed to have been accepted the terms and conditions set out therein. Where the prospectus expressly reserves the right to revise the fee structure in accordance with decisions taken by the government, the institution may, in appropriate cases, enforce a mid-session enhancement of fees even in respect of existing students. It is it is pertinent to note that, so therefore facts are admitted. It's a midterm, so that's why I said the fundamental question which will affect, and in my understanding, as my instructions is that most of the colleges, engineering colleges, they do not disturb once it is admission. They hike, but it affects to the next students who are taking admissions. Now, if I go to the judgments. On a direct point, only there is, on direct, there are some indirect points, only one judgment, that too by the Honorable Single Judge of Uttarakhand High Court, only for persuasion purpose. Not even that much of, I would say, reasoning or too much, but it's a directly on that point. This is Bindia Khatri. The copy was given to, I give another copy also. Paragraph 14, 15. Can we come to 14?
Yes.
In this writ petitions, petitioners have questioned the authority of the appellate body to apply the fee determination made by the committee to such students who took admission in preceding years. It is contended that fee determinations can be applied only prospectively, and students who took admission in previous academic years cannot be asked to pay the enhanced fee determined by the committee in subsequent years. This court finds substance in the said submission in view of the provisions contained in their regulations, subsection 12, 13, 14, such and such. The tuition fee payable by students of a private unaided professional college can be revised only as per determination made by the committee. Every college before commencement of, here also in our regulations, commencement of academic sessions will have to require before the committee the proposed fee structure, and the fee determined by the committee shall be applicable for a period of 3 years, and after expiry of 3 years, the college would be at liberty to apply for revision. It is further revealed that fee determined by the committee shall be applicable to a student who takes admissions in the same academic year in which the fee determination is made, and the fee payable by such students shall not be revised till she completes the course. That's just entire completion of the structure. The Honorable Single Judge has distinguished it by referring that it was under a separate law. That's a distinguishing thing. Now the next judgment. This was the Constitutional Bench judgment. It's 2003 6 SCC 697. It was comprised by Honorable 5 judges. In fact, it is not a extremely direct point, but just to satisfy your lordships that they don't have any power, because it was also decided in this Constitutional Bench judgment. Paragraph 6, the questions 6.1. That they don't have any power. They are regulated. 6.1, whether the educational institutions are entitled to fix their own fee structure. Now kindly come to 7. 7 paragraph, it's the page number 721. Just one line above placitum G. Once fees are fixed by the committee, the institute cannot charge either directly or indirectly any other amount over and above the amount fixed as fees. If any other amount is charged under any other head or guise, that is donations, the same would amount to charging of capitation fee, which is not permissible. Now, this is, I must say one thing, this is not direct judgment whether a midterm or not. This is only a judgment that shift happened. Like it's not you, it's a committee. There was Next, my lord, 2005 6 SCC 537. This is also another constitutional bench judgment. Again, it's a 5-judge bench. There, my lord, paragraph 147, page number 607.
Yeah.
My lord, may I also show the paragraph 145?
Hmm.
145. Suggestions made on behalf of the minorities and non-minorities that the same purpose for which the commission have been set up can be achieved by post-audit. That sentence is not necessary. From unless the admission procedure and fixation of fee is regulated and controlled at the initial stage, the evil of unfair practice of granting admissions on available seats guided by the paying capacity of the candidates would be impossible to curb. That's general understanding that transparency why required. So I'm only on the word initial stage. So that was also in the mind of the Honorable Supreme Court. Then 146 last line on through a fair and transparent admission procedure. That's the reason, my lord, in my list of dates that process and based on a reasonable fee structure. So therefore choosing after seeing the fee structure. Then 147, in our considered view, on the basis of judgment in Pi Foundations and various previous judgments of this court which have been taken into considerations in that case, the scheme evolved out of setting up the two committee for regulating admissions and determination fee structure by such and such cannot be faulted either on the grounder, but that's basically that they don't have power. It is the committee on that. No, which one? That is no, not necessary. Well, these are
These last two are mostly on the committee's
so
powers.
that's the reason I say that I spend more time on the dictionary, because there is no, in fact, there is accepting that Uttarakhand honorable single judge, it was really on midterm, but I haven't been able to find any direct judgment that once a student takes admissions, maybe for the reason that
There's a coincidence in the previous judgment which you cited, Islamic Academy.
yes,
The last page of that, another Karnataka versus TMA Pi Foundation case
yes.
starts. But that's a different year, 2003. And this was 2002. Pi Foundation has been considered here in your judgment.
Well, this was since it was it involved variety of other questions also, including the whether minority can have
Where Islamic society, that Islamic Academy ended that judgment,
yes,
there's another Pi Foundation starting there.
yes.
But you have not cited that, so we are not looking.
No,
Yes.
no. That is, my lord, that is
Correct,
too
yes.
larger issue that is not
necessary, yes.
required in my case. Now, my respectful submission, my lord, I rest my case purely that they have not denied, neither the honorable single judge has questioned that this regulation, that 7.7, is not applicable. Now, if I read, my lord, I will be reading the 7.7 once more and I will conclude my submissions. To my understanding, my lord, 7.7 requires no different view at all, because of the reasons of these words. Word number 1, intimation to competent authority. So therefore, they don't have in advance. Then the fees chargeable for the entire course. Therefore, chargeability of the fee, it is not for intra semester. It is always for the entire course, which they use in 74 as structure. And then commencing from, the next word, the commencing from, that again shows, my lord, same their page, it starts, completes. Even the words for which admission shall be made. So it was all over, so far we are concerned, by September, 16th September. And then also the next sentence, the total fees Here the total cannot be, my lord, conceived of total for a one semester. Total fee shall be divided into the number of years. So therefore, the clarity at what point of time, how much amount of money parents have to be ready with. Or as the case may be, the number of semesters of study for a course in the first instance, fees only. But these are my respectful submissions.
My lord, there is three matters, my lord. All the matters learned government pleader is leading us, my lord. Due to resolution, my lord, he is unable to appear today before your lordship, my lord. Kindly give us another date to kindly hear the state, my lord. We have filed all the matters, our affidavit, my lord, in the
Refuse. The college is
Sure.
before us. We'll hear the college. Yes.
Lord, kindly, my lord. I am appearing one of the matter, my
sir.
lord. Kindly accommodate another day, my lord.
No.
Kindly, my lord.
Please, Mr. Bhattacharya, please. Yes.
A notification was issued by the state government, admittedly. Now the fee structure was introduced, revised fee structure, I should say, was recommended during October 2023, during the first semester was going on. Well, that was related to 23-27 session. First semester started, by that time, fee structure was introduced new. College authority has not introduced the fee structure in the midterm of first session. We have only, my lord, introduced the new fee structure from January 2024 onwards. Not that, my lord, one was prejudiced or affected.
So, Bhattacharya, the course is, what is the length of the course?
That is 8 semesters are there, 23 to 27, 4 years course.
4 years.
But out of the total bunch of petitioners or appellants or the students in large, my lord, of the college, my lord, total 652 students are there. Out of, my lord, them, 353 has already paid the revised fee structure. My lord, this is one of the college under, my lord, Abdul Kalam University. My learned friend is representing.
No, I don't think it. But I'm representing all the private colleges because the first prayer is for setting aside of the notification. I am the society.
You will be affected. You will be affected. We'll hear you also.
My submission.
We'll definitely hear you after, Mr. Bhattacharya. Yes.
Well, so far as the other colleges under the Abdul Kalam University is concerned, my lord, technical colleges as that of us. My lord.
You are the university itself.
I am
You
the
are
college.
The college.
I am only the college.
Oh, you are the BC. Right?
Yes. Now, my lord, other colleges, my lord, in my lord, also college, my lord, of pharmacy, where, my lord, I am also, my lord, introduced the set fee structure. No one disputed that, everyone is paid. My pharmacy college, my lord, out of 306 students, 259 already paid the fee structures. This fee structure was outcome of a conscious discussion made or deliberation made before a committee constituted, headed by a ex-judge of this Honorable High Court. That committee, my lord, considered, but that has been held by the Honorable High Court, my lord, in the trial court judgment also, how this fee structure has come on the way. My lord, the requirement, infrastructure, educational facility, other additional facility to be catered to the students that require for 10 years, almost from 2006 onwards, 2000, my lord, there was no, in 2016 onwards, there was no hike of the fee structure. It has been only done, which could have been done within 3 years. As judgment, my lord, has been cited by my learned friend that 3 years span, otherwise you cannot. From 2016 to 2024, I should say, because we introduced to you, no revision of fee structure was made. In the meantime, revision of pay of the teachers came, which we had to introduce. Other infrastructural expenses and all allied expenses have given a hike. we have a chart even, my lord, which we should be permitted to disclose as to what happened. in
Was
the-
it before the writ court, Mr. Bhattacharya?
No, my lord, this is the
Then-
development taken place, my lord, how the payment has
Then
been
don't
made.
this. But we'll take notice of your arguments.
My lord, conditions, my lord, when at page, my lord, I don't know, my lord, what motive, কোন রিটটা প্লেস করছিস তোরা? গৌরব কুমার সাহু দেবজ্যোতিষ কেসে তোমাদের ফি স্ট্রাকচারের পেজটা কত রে? 74?
74 হচ্ছে
74, 75 are the fee structures.
মানে ফি স্ট্রাকচার, may I
82 is
take
your notification. That
fee
notification.
structure itself, my lord?
Yes.
Kindly come to the second page of the fee structure.
Yes, Mr. Bhattacharya.
My lord, kindly let us come slightly at the bottom. Fee structure is subject to change from time to time as per the government decision.
Yes.
My lord, this fee structure, my lord, someone is accepting. My lord, he is also accepting the condition that it is a government decision, it comes on the way, we are to accept it.
So,
As a-
Bhattacharya, can there be a estoppel against the statute by contract? Can there be a contract entered into which is contrary to some law or anything having the force of law?
My lord,
7.7 is staring at our face, subject to interpretation of 7.7 by you, definitely. But can there be any contract? This is by way of a contract, because the moment the student takes admission, it's a contract. And the learned single judge also held that this is a contract. We agree. But then the larger question is whether the contract can be there contrary to the law.
my lord, once you accept it, you should have challenged it. Once you accept it, you should have challenged it. Condition was imposed there, my lord. It is the government to answer your lordship, because they have given the fee structure, they have made a notification. We are only, my lord, implementing authority. We cannot change the fees. As a college, my lord, we are the receiving end, my lord. We cannot change it, we cannot alter it. Even 10 rupee, my lord, we cannot increase. It is the government, my lord, who has, my lord, taken it. But committee also, my lord, has applied it. I don't know committee report to be submitted by the state government. My lord, this was supposed to be, my lord,
You say the committee was intimated.
committee was very much intimated, and committee had a deliberation of the from the students as also the colleges, my lord.
So, Bhattacharya, if that is reflected from the learned single judge's order, then we'll accept that, because you must have argued that before the learned single judge.
My lord, the issues have been considered by the learned single judge. My lord,
The
if you
learned
lord-
single judge's judgment says somewhere that you have argued it even if he did not decide, we'll accept that.
but that issue has not been raised there. May I take your lordship, my lord? Kindly come to, my lord, the
Yes, Mr.
learned single judge's judgment,
Yes.
my lord. That was from internal page 4 onwards.
Huh.
My lord, this is something, my lord, lordship has gone through the judgment as a
Not
whole.
the entire judgment, but the relevant portions. Before that, the discussions were.
So far as the regulation 7 is concerned, my lord, at internal page 5, my lord, the learned single judge has said so, has dealt with.
Even thereafter, that has been considered. Regulation has been interpreted by learned single judge in para 46. At para 46, learned single judge says, therefore, the fee structure has not been treated as indivisible, either under the 1994 regulations or under notification. So even the 1994 notifications. And para 38 also, regulation 77 is considered. It mandates that professional colleges shall intimate the competent authority in advance. But we don't find any statement recording here to the effect that the fee structure that it was intimated to the committee or was a part of a process of discussion and deliberation. We don't know. It may be there somewhere. We are trying to find it.
My lord, there
That
was,
you argued even. Arguments have been recorded. We are overlooking Mr. Dhor's argument, which start from page 22.
my lord, page 13, paragraph 35 onwards, if I place,
Para 29 onwards is your submission, the state submission. And
Yes.
there it has been argued.
yes,
Para 29, what you are saying has been argued, Mr. Bhattacharya. So not that it was not early. So therefore, we take it that it was argued because it is recorded. He specifically argued that in accordance with provisions of applicable legislation, a fee regulatory committee was duly constituted. That committee recommended enhancement of fees.
Yes.
So it was made.
And pursuant to such recommendation, the fees were revised.
Since this was the state's argument, we are using this tag.
Yes.
Yes.
Lord,
Uh,
each and every matter we have filed our opposition in the honorable single bench. It is also here.
You cannot plead law in opposition, but you have argued that also. And we take your, we accept your contention that there must have been something before the learned single to show that this was done, this exercise. Very good. We proceed on that premise, Mr. Bhattacharya.
Implementation of the notification 1610 petitioners and other students admitted to BTech course has for the batch number 23 cannot be said to be highly unsustainable. The court's finding.
Legally.
Page 29, paragraph 29.
29. Yes.
And Mr. Chakraborty, learned advocate on behalf of the respondent number 13 to 14 contended the course fees is self-financing engineering colleges have not been revised for the last 7 years.
That which you are submitting.
You are submitting that, Malad. Also, Malad, that is a fact.
Right.
And paragraph 12, Malad, what we submitted. Malad, paragraph 11 onwards. BC Engineering College is a small self-financing professional institution approved by the All India Council of Technical Education and the Department of Higher Education, Government of West Bengal, and affiliated to Maulana Abdul Kalam Azad Makat, and that it is governed by the regulatory framework prescribed by the...
So we are not looking at the respondent's case and the writ petitioner's case because that is the case made out in your objection, opposition and this. The arguments, because whatever you press during arguments, we look into that. Those have been recorded at length from page 8, para 22.
Yes.
So we are looking into that you have argued. The state and you have argued. The state has argued that there was a due appointment of a fee regulatory committee. And you also argued, Mr. Bhattacharya, that last 7 years it was not revised, as you said.
Yes.
And also that the point which Mr. Dhar pointed out that played in the mind of the court at page para 32, different legislative frameworks, those judgments. So those are not applicable.
And what has been taken into consideration by the committee, that's also been argued, my lord, that since infrastructural cost and other...
Mr. Frankly, we are saying that we agree with you to the extent that if a committee, an expert committee has taken a decision, we won't enter into the merits of that decision. That probably we have our reservations whether the court can do that. Right. We are not experts. It has been held time and again. And if experts were appointed, that if there was an expert committee, their say in that regard, subject to hearing Mr. Dhar in reply, in our opinion, will be final as regards the suggestions. The binding effect, the interplay, the question here is, Mr. Bhattacharya, primarily interplay between rules, regulation 7.7 and the notification 1. Secondly, the interpretation of the expressions used in the in your admission that form, page 74, 75 itself.
Yes.
These are the two considerations which we will look at. Because if the expert committee has taken note of this and come to a conclusion, merits of that conclusion, qualitatively, we cannot go into.
No, that is not a subject matter of challenge even. That is not an issue even, so far. Regulation 7.7. Now, regulation 7.7. Well, definitely he has a statutory flavor.
A pungent statutory flavor for you. Because it's very clear. Apparently, entire is entire. I mean, how can you see entire differently?
Well,
structure, apart from Mr. Dhar, we are supplying arguments to you also, Mr. Bhattacharya. Mr. Dhar has told us one meaning of structure. Oxford Black says so. But structure may also have, in common parlance, it may also have a connotation of breakups.
Yes.
Breakups. So structure may not
floor-wise.
Floor-wise, the breakup. Structure, session-wise here.
Yes, yes.
So the fee structure may refer to the structures. But entire is playing in your minds most strongly. And this time to time, why shouldn't it be? Because there's only one way of harmonizing regulation 77 and this initial notification and your subsequent notification, which would be that the time to time, yes, state government in conjunction with you may increase. That time to time should be read with regulation 77, and to be admitted should refer to that also, if there is any scope for further admission mid-session.
That is so. But
How do you get over regulation 77? That is your main problem, Mr. Bhattacharya. Because what the government did in its rather legislative capacity cannot be undone by in its executive capacity.
well, regulation 77, may I place it 1 second, Your Lordship?
You convince yourself. If you are convinced, you are that it can mean
The
entire can mean
professional
something.
college shall send intimation to the competent authority in advance. The fees chargeable for the entire course commencing from the academic year for which admission shall be made. The total fees shall be divided into number of years as the case may be. The number of semester of the students for a course. In the first instance, fees only for the first year or semester shall be collected. The fees are leave it. Lordship is, my lord, what is troubling us, my lord, with the what? The entire course commencing.
And in advance.
And in advance.
Read together, Mr. Bhattacharya.
But in advance has been shown. Not, advance has not been, my lord, deviated. It was, my lord, notified prior to the admission.
No, if in advance is read in conjunction with entire course, then that advance had to be prior to the entire course, commencement of the entire course is from commencement till end.
Yes.
So in advance to that means prior to commencement of the course.
Prior to admission in the first semester.
Exactly. Exactly.
Prior
sir.
to admission in the first semester.
Precisely.
So 23-27 fee structure was shown at page 74 or somewhere.
Yes.
Malad, that was, Malad, in advance it was notified.
Yes.
Am I right?
And in terms of that, they got admitted also.
Advance it was notified.
That there is
That
notification that.
notification is not a subject matter of challenge.
No, no, no. The subsequent fee hike was not notified in advance before the admission. That is what they're challenging.
But that was Malad, indicated in the said notification itself that it is subject to government modification.
From time to time.
From time to time. Yes. Therefore, this is a qualified fee structure, Malad, indicated with the condition that probably, Malad, that was in the mind of the college authority that government is in session of the issue regarding the
College authority had actually did not have much say probably because it is subject to government and we have to interpret that. I mean,
we had a deliberation to the committee because of our requirement and why it is required to be for 7 years. It has not been done. So we had a deliberation. We are directly affected by the decision, otherwise one way or the other, prejudicially or favorably. But we are, Malad, indicated therefore consciously. We have consciously, we did not wait till the committee's result coming. Malad, we have indicated consciously that fee structure is subject to change. Whatever I have given is not the final. It's subject to change as per the government because that was under the authorities' conscious consideration. And Malad, to run the college, Malad, without the revised fee structure is absolutely impossible for us today. And
but college... it was impossible when you took admission also. Why didn't you think about it before the admission process?
No, we cannot increase it. We should have stopped then. Then we should have stopped the admission as a whole. No, we cannot do this. Stop it. Revision unless comes, I am not going to
you said that the
carry on the college.
Took place in 2016. Before 2016.
After the notification.
So from 2016 till 2024, you have been running the college. You have been taking admissions.
We have been deliberating to the authorities, to government.
Yes, but you could run the college. And you did run the college. You did not stop the college. Not that you're doing it gratis. You're also earning from that. It's not a totally charitable institution you run. Engineering colleges earn sufficiently.
In comparison to the similar fee structure of other colleges, but in the same level under the Macau, my lord, is much more than what
We
we have.
fully understand the hardships the colleges are facing. But whether these students, the current students should be subjected to this, or it should start from 2027 onwards, or at least after this date of notification, whatever sessions. That is the question which is troubling us, Mr. Bhattacharya. Otherwise, yes, we agree. Colleges run in with meager fee structures and all. Maybe compared to, I mean, since it's an engineering college, you have your expenses. We agree. Everything is increasing. You should also increase. No doubt. We have no qualms. Government has the authority to increase also. But whether that should apply to current students who have some aspirations, they have joined this. And Mr. Bhattacharya, nobody would come to court. You say that some have paid, maybe substantially. Even if one student did not pay, that student could not. That's why he has challenged in court. Now, otherwise, nobody would incur the expenses for a court litigation or run to the court. A student would not run to the court. How many students, if I were to face such a situation, I would not run to court first.
Out of the appellants also, my lord, a large number of persons have already paid. 94 have paid.
As you said, Mr. Bhattacharya, even if one remains who has not paid,
And he has preferred an appeal accepting the order, acted upon the order.
no,
He has accepted the order.
at least one appellant, all the appellants
But
have paid.
let that person may not be the appellant here before your lordship, because he has accepted the order without prejudice. 94 persons have paid.
No, that was under compulsion, Mr. Bhattacharya. They would have lost a year then.
No compulsion for why?
Yes, they would have lost a year, academic year. What are you saying? No compulsion. They would have lost an academic year.
Therefore, everyone is capable of meeting the demand of the college.
Don't know. We are not looking into their coffers and seeing how they have managed the money, Mr. Bhattacharya. For all that we know, they may have mortgaged so many things. Haven't you had ever any client who says that I have to mortgage my things to pay your fees, and that's why you waive the fees? You must have had such a situation. All of us have. Haven't you refunded fees after knowing that they have mortgaged something? Hasn't such a situation occurred in your professional life? Must have.
Always.
Every one of us has suffered. I mean, faced
say
that.
it, my lord,
Every one of us has
know
faced
what
that.
plight the person has suffered from. We know
So
that.
therefore, we don't know. Not that this is probably not a viable logic that they have paid, therefore they can pay.
No, I am not saying so. But they have paid, therefore they cannot agitate before the appeal court. They cannot be a party to the appeal. 94 have paid
We'll
and accepted it. Whether they can be a party to the appeal or not. My lord is not saying that revision is higher is good or not. Only the my lord, the state is to answer your lordship about the my lord, change of the fee structure. And
no, we are proceeding for the time being on the basis that because their affidavits were on record, and your learned friend says that yes, they had a committee deliberation on this. For the time being, we are proceeding on such premise, subject to that being falsified by Mr. Dhar.
No, I agree that. That's fine. I have no problem.
We are
They
proceeding
can-
on that basis.
I say that that amount is perfect, but who are going to take admission? Even you start from the very next year.
But otherwise, they wouldn't have a choice now.
Well,
Now they're a dog in the manger. They've already taken admission. They cannot go to another college now. A lesser remunerative, I mean, lesser fee college. They cannot go now.
the expert committee has implemented it from 23-20.
That is where we come in.
That is
That is where the court comes in.
expert committee is that particular decision of the expert committee. my lord,
Expert committee is an expert on the fee structure, but not on
effect
law.
has been given
not
on
on
that
law.
day. But that is a recommendation made.
Hmm.
And if that recommendation is my lord, not followed by us, my lord, we will be my lord,
No, you will, yes.
we have also my lord, deferred it recommendation.
We can help you by sitting inside that. No difficult. We are always there to help colleges. Very well, Mr. Bhattacharya, we are taking note of certain things, arguments you make. One is that expert committee was appointed, therefore there is no illegality regarding that. Second is that in the initial fee structure published to, given to them, it was categorically mentioned, it was qualified by state can change from time to time. That was there, and that some of them have paid. So at their behest, no appeal should be maintained. They
That is
should not be permitted to prefer an appeal. These are your basic subjects.
And this is my lord,
Except 94, other students are not paying area, either old or device.
my lord, accepting 94, even there was an order of court, my lord, that that is not a strong point for me, but still a fact, my lord, remains that they are taking advantage of the court proceeding and not paying even in the unrevised rate. That
No,
is
that you will make it clear.
that-
You are.
that
No,
is
would
one
you
aspect.
accept that? Even if they went to pay that,
I am not accepting, but
you would not accept
during the
once the fee is increased. If I go and say I'll pay
what
half
is
the
the
fees,
impact of the said result, my lord? Ultimately, my lord, if the fees increase itself, my lord, is affected, then it will have a greater effect over all the colleges, my lord, under the.
they will have to wait for some more time. See, they have waited from 2016 to 2024 for 8 years. They'll have to wait for 1 or 2 more years. 27. So 1 more year. The balance of convenience is squarely against you because you will have to wait for 1 year. 1 year more from today.
No, we
And
have
these
given
people
it
will
from
lose their careers, even if one remove.
we have already, well, 24 onwards, well, we have implemented it. We are in 26. We are
The
in
larger
26.
consequence is that you have to refund the excess. That is a larger consequence for the colleges.
Those who are not before your lordship will not,
If you set aside the notification, then they'll come tomorrow. They'll not come to us even, go to you directly. So we are also thinking of the larger ramification, Mr. Bhattacharya, that we all have to consider.
well, give a day more, my lord, to complete our submission.
No, we
discuss with the authority for once tomorrow at the morning.
We've not discussed with the authority. We have heard it sufficiently. We'll hear Mr. Chakraborty conclude arguments. Yes. Appeal was filed some time back. This has been assigned to us recently.
Yes.
It was filed some time back. The learned single judge who was a part of the bench, that's why it was released.
Yes.
So at that point of time, we must have been prepared in the matter. Yes.
We had used an opposition before the honorable single judge. The opposition is annexed, but the annexures are not there. I have only one copy. I tendered an unconditional apology for that. 2000, the committee page, I'll be relying on page 74, 90 and 91. And tender apology. But 74, my lord, would find the committee says I will not revise it this time. Kindly see page 74. 2000, that is of 2017. 90, my lord, kindly see page 90. At 90, my lord, may I do it? Tender apology, my lord. I don't. 90, my lord, I being a associate, the president of this association, which is society registration, was asked by the committee to attend a meeting. So deliberation, and 91 also, my lord, would find the colleges were invited. 90 and 91. No. Annexures and 90 and 91, my lord, would find the president, who is a party, my lord, was called. And there, well, before that, there have been at least 150 letters, out of which 30 letters have been annexed. The colleges are facing steep financial crisis, competition. My lord, we are not having the best of professors, intellectual capacity. We have indicated all this. We have given a comparative chart to any other college across the country, my lord. We are the lowest. Now also the difference is, my lord, 75,000 and 1,10,000. The enhancement is not so much semester wise, 1,10,000 at the most.
Per semester?
Yes, past semester. It was 75,000 and there was an increase past semester. May I just show the previous notification?
No, to how much?
1,10,000. As per the notification, which is under scrutiny before.
35,000.
Yes.
So made about 1.5 times.
Possible. Now, my lord, an argument has been placed. This entire fee structure, my lord, I have a different take on this, subject to my lord's consideration. My lord would kindly see the regulation once. Subject to my lord's consideration.
Yes.
My lord, kindly see 7.1 first.
Yes, 7.1.
The tuition fees and other fees for a professional college shall be determined by the state level committee, as has been done in this present case. Now, my lord, 5. The fees. 4, my lord, the committee shall give an opportunity to professional colleges to place such material as
Done. Here it has been done.
May
You have been given a notice and all.
The fees chargeable in professional colleges shall be determined on the basis of estimation of expenditure of the professional colleges for its efficient
These are the
function.
parameters for the fee structure.
Now, number 7. A professional college shall send intimation to a competent authorities in advance the fees chargeable for the entire course commencing from the academic year for which admission shall be made. By pausing for a hearing, the decision to be taken, the timing is not given. It is only an intimation to the committee. Then the committee will decide this issue. After, my lord, whatever the paraphernalia is has to be maintained. So 7, my lord, is not on the point of time to be decided. It does not say, my lord, this has to be decided 1 year before or 3 years before. My lord, this clause is something between a communication between the college and the competent authority. So, my lord, when I am speaking of a college and committee, whether this clause at all has any application in the present case. My lord, today, my lord, I come to this court and my lord said, you have filed the appeal much before, the decisions comes belatedly. My lord, can it be said for that 1 year I will not get the fees? My lord, 7 is only a communication. I am giving the communication, then it is up to the authority to decide. And the paraphernalia is, my lord, my expenses, my expenditure, all this to be taken into consideration. This process may take some time. That's why, my lord, in my opposition, I have annexed all the colleges across in West Bengal. Private college had mentioned this is subject to the government notification, any revised fee structure. But may continue with this. The total fees shall be divided into the number of years, or as the case may, in the number of semesters of a study for a course. In the first instance, fees only for the first year or semester shall be collected. The fees chargeable.
This may also come in your favor. In the first instance, fees only of the first year or semester shall be collected.
I'll be on that.
That may be a reason. The reason for that may be that it may change mid-semester.
That is what the single judge said. That is what the honorable single judge has said, my lord. That is why divisible. My lord, it is. It can be divided because it is year-wise, my lord. Year-wise, and this is again a communication. My lord, I am saying to the committee, this is my expenses, this is my, how the committee will decide, my lord, there is nothing, my lord, on record, my lord, at least how the committee will decide. Committee may say, you can change it from 3rd year, but 4th year. Only restriction is 7.3, my lord, I should point it out. 7.3, kindly see, my lord. The members referred to in clause so and so shall, no, sorry.
What does that?
No, my lord, there is one restriction, is there.
The fee, 4. The fees shall be fixed once in every 3 years.
Yes, well, that is 4. So, my lord, we are...
That period is over, long over.
So, that period, not 7 years, there has been no, from 2017 to 2023. Now, kindly see, my lord, the notification and the challenge. My lord has already had fallen from my lord that this is expert body. The decision, the merits of the decision, possibly, my lord, cannot be interfered under Article 226. Now, my lord, and my lord, there is no decision making, at least, my lord, my learned has not argued that there is anything infraction of law as regard to the decision making process. But the committee had given, the committee had to, the college had to send, the committee had to decide. My lord, kindly see. Notification.
This notification itself was challenged in the writ petition also.
Yes. My lord, only thing factually 2 things I wanted to show. My lord, I am seeing the MAT 267. My lord is
267.
My lord, kindly see 2 or 3 factual things. Page 50. paragraph 60. Man, this is part of the writ petition.
Paragraph 6.
6.
Yes.
That your petitioner state that the respondent authority concerned started registration for the first phase on and from 3rd to 16th October 2023 after the notification under the university. My lord, I have been told, my lord, that the colleges takes admission, but ultimately, my lord, it is finalized or crystallized at the stage of registration with the university. So university, my lord, all this started after the notification. Thereafter started phase 2 registration process for so-and-so for the year 2023-24 on and from 10th November 2023. Now 7. That your petitioner states after completed registration process in the month of December 2023. Thereafter, the respondent number 10 to 12 have been whimsically and arbitrarily demanding tuition fee so and so. So, December was the starting. If at least the writ petition is maintained in the matter, the cause of action starts from after December when, my lord, this fees hike had come up.
How are these relevant?
No, my lord, registration, I'm showing all this is subsequent to that notification. I'm just showing this on factual basis, on notification. Now, my lord, kindly come to the notification, page 82.
Yes.
My lord, now my second paragraph, my lord. Now the details of the fee structure stipulated in 2023-24 academic year are enumerated in this order. My lord, once it is said for the academic year 2023-24. And my lord would find the notification, the last line of the notification, it says they will take effect from the date of notification. So that's why the colleges have started from the 2024 January itself. My lord, it has not given any retrospective or anything like that. My lord, the notification has come into picture into 16th October 2023, and my lord, the academic session for 2023-24. My lord, I go back to regulation 7 clause 7. My lord, it only says intimation to the committee. Committee will decide as it is said. My lord, how it will decide, the paraphernalia will decide. The date is not mentioned, that the decision has to come within this. My lord, we cannot read into something which is not there, my lord, in the clause, subject to correction. And my lordship, it has also fallen from lordship, the last line year-wise. Year-wise, my lord, there has to be, my lord, today, my lord, if my lord sees 75,000 rupees from that was there prior to 2014. And today we are in 2023, my lord. There is possibly a revision of 8 years. But everything becomes priced. Remember, the teachers, if you have to have the best of teachers, best of academic infrastructure, my lord, we need this money. It is not something, my lord, which is out of, and my lord, there are, my lord, teachers has to be appointed. Why would the best of teachers will come to this college if we cannot sustain them? We cannot sustain. Man, this is my house.
I have one sentence just on interpretation of 7.7 later part. Can you take 7.7?
My lord, before the judgment, my lord, subject to correction, the judgment kindly see. Extremely sorry.
Nothing to be sorry.
The Supreme Court judgments are committee.
That is absolutely. Uttarakhand, my lord, there was a specific clause. The fees so determined shall be applicable to a candidate who is admitted to an institution in that academic year. And that fee shall not be revised till completion of his hard course in the said private institution. This was not there, my lord, in the regulation, the ICT regulation, nor in any of the notifications of the state of government. And that's why it was distinguishable, and this is what Honorable Single Judge has also said.
And, in my understanding, the later part of 7.7, if I can read, and then I say it's a restriction, what they cannot. May I read that? In the first instance, fees only for the first year or semester shall be collected. The fee chargeable by professional college shall be subject to say, that's not relevant. So therefore, once a student gets to know entirety, just because that the college will be able to ask for total amount does not mean in the first year the college is entitled to ask for it.
No, but we have to read the entire thing together.
Yes.
If 7 says a professional college shall send intimation to the competent authority in advance,
Yes.
such and such,
Yes.
and then shall be divided, etc.
Yes.
And then it's stated in the first instance, fees only for the first year or semester shall be collected. The fee chargeable by a professional college shall be subject to the ceiling fixed by the standing committee. So apparently, what Mr. Chakravarti says is seems to be correct, that it's an entire ecosystem.
Yes.
First, the intimation goes from them. That has to be before the academic. After you start the
Correct.
semester, you cannot do that.
May I
So you
say?
send it.
May I say the possibly there is a
Yes, and
another
then that might be the reason why you can charge one semester at the first instance, and then it will be subject to the ceiling.
ceiling
fixed.
is always there. What is well, my understanding is this as my learned friend has said,
What we say is, Mr. Thought, that you send the intimation, then you charge one semester only, which will be subject to the ultimate outcome of that. For that, there is no timeline. We'll come back and hear you on this.
Lord, I am in a predicament today because of the resolution of the bar.
Yes, but you can always cite that the court is not giving time. Put it on us.
No, my lord,
Put on, because the fate of the students is at stake, so we can't.
Lord,
We can't.
my lord, if lordship can hear
We,
them.
in
my lord,
other
hear-
matters, we'll definitely do.
But my lord, lordship can my lord, give an opportunity to address the lordship on, after they finish, my lord, not today. Any day, my lord.
No, no,
tomorrow.
today, please do it.
My lord, it's difficult for me, my lord. But I'm a member of the bar, but I cannot ignore the bar
Understood.
resolution. That's
Understood.
my
But
predicament. That's a,
but the difficulty is we are also a court of law. We cannot ignore the predicament
yes,
of the
lordship,
students.
lordship. I do appreciate
We
that.
are fully we always honor the bar's resolutions. Otherwise, we don't pass any adverse orders. But here, Mr. Dotto, we don't have any option. We don't have any option.
Exams are going on. That's all.
Exams are being held already.
Otherwise,
That's the difficulty. Otherwise, there would be no.
none of us
We don't
appear.
have fun in.
None of us otherwise appears. This is an
Under
exception.
compulsion, you can. There's always a safety clause in the resolutions. Under compulsion, you can appear. See, you choose your allegiance to the gown and the between the bar and the gown. You're an officer of the court. You're an officer of the court. You have three duties: towards the court, towards the litigant, and towards your fellow members. Now, two is always greater than one.
State has got nothing to lose.
Yes, that.
State, Mr. Dotto, we are telling you this. We are proceeding on the premise that this state had formed a committee, which your learned junior quite competently pointed out. Affidavit has been shown to us by Mr. Chakraborty as well. So that was formed, and we have expressed our opinion, prima facie at least, more than prima facie probably, that we won't qualitatively interfere into the decision taken by the committee. We cannot do that as a court of law. So that is the stand of the state, Mr. Dotto. That is the stand of the state. That you have taken a decision as per committee decision, you have done it. So we are not interfering qualitatively with that decision of the committee on merits.
I get you.
We are just interpreting law, Rule 77, Regulation 77. We make that very clear. We make that very clear.
My appearance today.
Yes, yes. Yes. Thank you.
On
Yes.
that 7-7. Though this has been read several times, may I read once more
Oh, yes.
before interpret? Professional college shall send intimation to competent authority in advance. The fees chargeable for the entire course commencing from the academic year for which admission shall be made. So this is the first part, for which the total fees shall be divided into the number of years, or as the case may be, the number of semesters of the study for a course, which is the structure in the table 74. Now, this part according to me is a restriction. In the first instance, fees only for the first year or semester shall be collected. This is nothing but to say, though the table is for second year, third year, fourth year, sixth year, but your right to collect at the beginning is only that table first year.
So this is not in furtherance of the concept that it can be changed later.
This does not tinker with the table.
All right.
It puts the restrictions of asking for any money from the table other than first year at first year. Now, page, there's a notification.
But how do you deal with this?
Yes.
It refers to intimation being sent previously, not the decision being taken, which has been
So
raised.
that's the reason I say that the very core concept of this hike, I'm not against. But the core concept is attached with admission. I don't say that the notification itself is wrong. I say the notification is perfect for everyone who takes admission after 16th. Even if in my batch, if someone takes an admission after 16th, he has to pay that. I say the note
should be read down to refer to the previous, the subsequent sessions.
Yes. I don't want that they should wait for 1 year. I don't want that.
That we understand, Mr. Dhar. But without Regulation 77, your the so-called contract That itself
Well, that
has a
82.
qualifier.
No,
times
may I say, they can come to 82 once more, because that's the government notifications that they are bound by.
to be admitted.
No, not only to be admitted. That part I missed. My learned junior has
Yes.
pointed this me. That to be admitted is there.
But
Now-
it refers to the
No, kindly come to the
2024 session.
last para of the notification at page 83,
Yes.
and the last few words. It will take effect from the date of the notification. Now the word to be admitted, 16th of October, coupled with what the statutory regulation actually wants of.
But Mr. Dhar, if you please see page 82, the sentence previous to be admitted, second paragraph. Now the details of fee structure stipulated in 2023-24
Correct,
academic
because
session.
someone might take an admissions for 23-24 after 16th of October. I don't make an argument that you don't have a right to ask for something differently post 16th. I say post 16th your right comes.
And it does not say 2023-2027 course or session.
No.
If that was said, then it would be very difficult to get out.
And that details, first it talks about the details will be given, details for entirety of the year. Then detail says, accordingly the tuition fee and other fees for the students to be admitted. Therefore, otherwise transparency, the regulation requirement of the entire coupled with the commencement and restriction. Just because I tell you that you are entitled to get the entire table, you don't ask them to give the entire money on the first year itself. So,
Last 4 line of
page.
page 82
Page 82.
first paragraph, last 4 lines. First paragraph.
This one accordingly.
No, the 4 years. The medium is all.
So what's your point?
উনি বলছেন এটা তুমি শুধু 23-24 এর জন্য, it's not for 23-24. It would be there for 4 years.
No, that's in fact, my lord, this once a this structure is made, it can go on for minimum 4 years, maximum.
But your admission was in the 2023-24 academic session
September.
only.
By September, everything was over.
Yes, so how can we give effect to this notification regarding 23-24 other than by operating it in respect of those which have?
Because prior to this notification,
There be any after this?
no,
would
there
there
was
be
an
further admission?
there was an earlier notifications on which basis college was doing
Right,
everything.
but how can this notification be given effect to regarding 2023-24 academic session? Otherwise, than taking it to be applicable to the running course.
In those cases where there are, my lord, thousands of colleges.
Well, 11
Admission is
November,
for
December also, November, December.
I don't know, may not be in engineering, may not be in engineering. I say that the notification is connected with to be admission. What for? Because the regulation 77, it talks about entirety. And Mr. Chakraborty's that interpretation, in my understanding, this is only a restriction. That's a restriction. So there is a ceiling and there is an entirety. And I have no, I don't say they have to wait for 1 year. I say that once someone is admitted, thereafter you cannot change because of this.
So then regulation 77 in terms is not applicable because it refers to intimation being sent prior to the session, not the decision being taken.
May I say this?
And you have to proceed on general principles. Of
Yes. Now their intimation is for the entire. The decision is also for the entire to be admitted. If that is so, then otherwise, my lord, the transparency that requires that prior to admissions in the counseling process, whatever would be the fee structure would be there on which basis they can take an admissions. Because otherwise, my lord, I don't find this 7. Yes, one interpretations can be taken. It has got nothing to do with when we will be paying the money. It is only between the college and the committee. But the college and committee, that gives a clear indications that this under 7, when they would be asking for the hiking, they would be asking for the hiking for the entire course. And this is relatable to for which admission shall be made. But you may kindly these words, for which admission shall be made, that is reflected in to be admitted. So statute says entire for which admission shall be made. And they also said, that's why I said notification, I don't find anything wrong in that. I say the college, they cannot give an effect to the notifications to the candidates who have taken admissions pre 16th of October 2023. Now, these are my.
So that may be taking away substantive rights retrospectively also.
Yes.
That line you may also have.
And that line, my lord, that line of in this structure 70 page 75, that fee structure is subject to, because it is there, my lord, the definition of structure I'm saying. Because
so they have changed the entire structure.
They have changed the infrastructure. For an example, what now?
They are not changing semester wise.
Correct.
They have changed the entire thing semester wise, but entire thing.
Right. But my respectful submission is this: once they change the structure, this structure would be applicable for whom? Will it be applicable for the students who have taken admissions, or it will be applicable for the students who to be admitted? Because if it is for already admitted, then it becomes a midterm. And effectively, this, my lord, this.
But as per the curriculum, Mr. Dhar,
yes,
academic year 2023-2024 cannot, by any stretch of imagination, start after from November 2023. Must.
It may not. I take it may not. I take it may
this
not.
is unqualified also.
I take it is may not.
To be admitted is there. You are right. So you have to reconcile between the two.
And also it takes effect, my lord, from the date of notification.
Yes.
So therefore, it takes effect from, so not pre 16th of October. My instructions are that they have possibly, because I don't have the documents, that for the last year students, they continue to the old.
But that is previous to 2023-24.
No, I said that those who are in the college itself and they are continuing. My lord, in first year students and the last year students, there would be difference of the fee structure. It is not that once the fee structure is changed.
This is applicable at the time of, if the admission is for 23-24 academic year.
Yes.
If the admission is in that session.
Yes.
Academic session, then this is applicable.
Yes.
From then.
Correct.
So there is only one batch which has taken admission for the academic year 2023-2024. As
all
far
of them
as
all of them have
at least BCRI, this college
Correct.
is concerned.
All of
so there is only one batch which takes admission in this session.
Yes.
There is no further batch because there can be several instances of admission.
Correct. Correct.
So therefore, let us take BCRI college.
Yes.
They have one batch only. It can refer to only one particular batch, 23-24. Won't apply to previous batches. So you fall under that category.
No, Lordship, may kindly take the first paragraph then. Regarding the fees of the undergraduate engineering and technology, pharmacy and architecture programs conducted by the private self-financing engineering and technology, pharmacy and architecture college, this governor is pleased to order that the fees structure for the programs conducted by the private self-financing engineering and technology, pharmacy such and such of the state will be continued for at least 4 years for BTech and B Pharma courses and 5 years for B Arch courses with effect from 23-24 academic sessions. So therefore, once it starts, it will continue for at least 4 years or at least for 5 years. It may be more than that, but at least 4 years it will be same. Now, third paragraph, it says, accordingly, the tuition fees and other fees of the students to be admitted in the first year. There lies the thing. So similar kind of notifications was there for on which basis they prepared page 74 and we took the admission. and that notification also had some continuity. Now a new notification has come, and as like any other thing, there has been a hike, and this is not my case that there should not be any hike. Question is of applicability. It will affect already admitted students, or it will affect ongoing students, or it will affect to be admitted students. Whether the academic year,
Irrespective of 7-7, because 7-7 does not help you much then.
7-7, well, 7-7, it helps me in a
Cannot
sense.
read decision into intimation.
Well,
You have to rewrite the statute then.
no, I said 7-7 is the clear indication that whenever they ask for it, they ask for a structure for entire course. And admittedly, my first semester, they have taken the old on the basis of the previous structure of 74. Now they want this to be, they are not asking that you have to pay a separate thing from the first semester. They said from the second semester onwards, you have to be guided by this.
No, but Mr. Dhar, you tied your argument to 7-7 in the sense that we were thinking of this as a decision, because that has to be that adjudication, the decision of the fee structure, new fee structure must be there before the start of the academic session. But that goes in view of this language, sent intimation. So it's not the decision to be taken.
No, this is
so fee structure need not be fixed prior to commencement of the current academic year.
Ideally, it should, because it will be helpful for the college authorities. They will get a clear cut also for the students.
But this does not say either way. This says intimation has to be before academic session. But this does not say that the fee structure has to be fixed before the academic session.
No, it doesn't say,
say that.
Correct. It doesn't say that mandatorily. It doesn't say so. But I would be not stretching it. But
then we have to read something into it.
Yes, but that reading part, I say that. May I read once more and the last time? A professional college shall, because sometimes what happens,
we have already been doing it during your argument.
Yes, that
something comes out.
Something comes out.
We tried that.
Professional college shall send intimation to competent authority in advance the fees chargeable for the entire course, commencing from the academic year for which admission shall be made. So this part, that for which admission shall be made, that part, my lord, in my understanding,
this refers to the time when the intimation is sent.
Yes.
At that juncture,
yes,
this
yes.
would be true.
At the same
Admission
time,
could be taken.
Correct, but at the same time, for which purpose they are doing it?
No, purpose is not here. They say intimation to the competent authority in advance.
Yes.
The fees chargeable for the entire course commencing from the academic year for which admission shall be made.
But for the reason for which admission shall be made.
So I send the intimation for the academic, the entire course,
yes,
commencing from say 23-24. I send it say in 2023.
Yes.
The earlier part of 23 or before the session begins.
Correct.
I do it. There is nothing else to mandate anybody, either the committee or me.
Committee can take a decision after 5 years also.
Yes.
Because there is no such thing that committee has to change it in every 3 years.
They only have to show that the intimation was sent prior to this. Statute only mandates this.
I say that
nothing more, nothing less.
Correct. Intimation for
the academic session which is to begin.
Yes.
At the point of time when the intimation is sent. It's future tense at the juncture when the intimation is made.
Correct.
Not future tense when the decision is taken.
Correct.
Need not be or maybe
Correct.
or may not be.
Correct.
Not by virtue of this.
But the ultimately on the basis of this regulation, the notification which has been brought in, that has come after our admission.
True. Under general law, under general principles, we can consider. But 7-7 does not prevent them from doing it. Or the committee from taking the decision even after the commencement. Per se, 7-7 does not say that. Per 7-7 only puts one restriction. Intimation has to go prior to commencement of the session and for the entire session, which is about to commence.
Yes.
Yes.
Well, I was on 7-7 on the entire part.
So obviously, Mr. Dhar, they have to send the intimation regarding the suggestion or intimation regarding the entire
True.
session to be commenced.
True, true.
They cannot do it piecemeal.
Correct.
They have to say, I am distributing it like this, session wise, this is the
No,
distribution.
what I'm saying, can you think of this possibility? So they say that because the courses are not for just 1 year or 2 years, yes, mostly 4 years, 5 years. So entire means if they ask for it the entire 4 years.
So everything after intimation pertains to the entire block of the course.
Yes.
Entire block of the course, which is in future tense.
Yes.
But this entire future tense in block, that is pertaining to the point of time when the intimation is sent.
Yes.
It's tied to the intimation.
Yes.
So when I send the intimation,
Yes.
it's future tense.
Yes.
For my upcoming academic session.
Yes.
The entire structure.
Correct.
Everything, whatever you are saying is correct.
Correct.
But that is true
Not-
at the time of intimation.
Not necessarily. I understand. Lordship is saying that doesn't necessarily mean that
Decision
that-
has to. This provision does not say that the decision has to. As per this provision, we can
yes.
utmost thing is that the
But I-
intimation has to be
I
sent.
take it. I take
We read. We have to interpret this notification itself to be admitted and whatever.
But 7.7 is not that I get my entire oxygen from 7.7
Yes,
itself.
that much we cannot read into a legislation. If this was pure executive action, we might have read down, modified, and give whatever nomenclature we like to that,
My lord,
and say it's in consonance with this.
correct.
Read up, read down. We
My-
can
my-
we could
my
do either.
submission is
But this is delegated legislation. It's very difficult to, I mean,
true.
put our own opinions into this.
Correct. Well, I'm not questioning the correctness of the quantum. My only point
No,
is
no, you are not saying that from the
Yes.
inception.
I say that
Point of applicability.
yes, point of
Incidence rather.
yes.
Incidence of that.
বলো মানে কালকে give you
2016 যে notification ছিল,
হুম।
that's came in June,
হুম।
clear concept যে admission টা subsequently হতো,
হুম।
to be
হুম।
that's the reason they said that of notification. I think
Okay.
they said that 2018 also. তো যে
No,
admission had
I
already
know,
been
I know.
taken, so this person should be
Well,
given
this
exemption.
correct. My lord, this is the notification that Lordship has just seen, and on which basis they are asking. It is not the notification is coming for the first time, so there is no such vacuum.
No, no, no. Previous notification is operative till this.
Therefore, the precise question will be, could be, just because a particular academic session has been mentioned, whether it will override the words to be admitted and thereby include already admitted students.
Last sentence, Mr. Dhar. In supersession of all previous orders and
Yes,
you can
but,
do that. Government can do that.
but yes, but kindly see the last 4-5 words. It will take effect from the date of notification, that is October.
It erases, supersedes the previous notification.
Yes, my lord, it
From that
supersedes
date.
From that date.
From that date, they can
Yes.
charge.
And that,
They can charge for the 2023-4 academic session.
my lord, the moment they
It's tied to 23-24. If 23-24 was not there, Mr. Chakraborty and company wouldn't have a case.
my lord, then
Wouldn't have a case.
may I say this?
But it's tied, everything boils down to 2023-24 session, academic session.
My lord,
You are covered by that
may
session.
I say this? If the interpretation is that from 23-24 session, they can hike. The obvious next question would be in 23-24 session, in the college, there are variety of semesters. Someone who has just taken admission, someone who is about to take an admission, and someone who is about to leave. Now, if this notification becomes applicable for everyone, irrespective of the admission being one of the qualifying point, then, my lord, at any point of time, it will be affecting, then there is no meaning, no transparency, no certainty on that table itself. Kindly visualize that aspect also.
There is no certainty. They are arguing because of the rider there. If it's not otherwise contrary to law,
Yes.
which apparently it is not contrary to 7.7, then that rider is clear. Fee structure is subject to change from time to time as per government decision. When you take admission, you subject yourself to that.
But there I say that the language could have been fee is subject to change. Then midterm fee can be changed. Once their language is fee structure is subject to change, then this fee structure means there is a table which is at page 74 that is subject to change. I don't say that there could have been.
They are referring to this particular fee structure because this
Yes.
features in this particular structure.
Yes.
So this refers to this particular fee structure.
Yes.
This fee structure is subject to change from time to time. This fee structure, which is
Correct.
from 2023 to
Correct.
27,
Correct.
this is changeable. We are putting it against you totally.
No, I understand, my lord. But the 74, they say kindly.
This is not a general statement.
Yes.
This is specific to this 2023-27 session.
Yes. They say that fee structure is subject to change from
This
time.
fee structure, we have
Yes.
to read this into this. Fee structure is subject to change from time to time as per government.
As
So
per-
the entire fee structure we can change from time to time, the government is saying.
Yes.
And then in this context, that notification comes and it says for 23-24 admission session, to be admitted, that language is, we have to reconcile that with 20.
Well,
but
that-
there is
that-
no other way of harmonizing it with 23-24.
Because I understand what Lordship is thinking. But then, my lord, kindly think of then there would be no certainty at all.
Won't be.
And there would be no meaning of taking a decision based on the fee structure.
It's a thought certainty by itself is not such a strong ground which we can incorporate into natural justice or equity. Because things change by their very nature.
Yes.
Everything changes.
Yes.
So certainty by itself is not such a strong parameter of natural justice or legitimate expectation even.
True.
We cannot read legitimate expectation in view of this rider in the original fee structure.
Well, the rider that Lordship is seeing, this rider, for the time being, kindly assume there is no rider. Does it mean that the fee structure, it is the law also?
Then there is nothing in this. Then you could plead estoppel directly. You could directly plead estoppel.
No.
I acted on their assurance.
Well,
they are changing.
my submission is
changing the rules of the game after the.
Well, in fact, they have changed the rules of the game. Why I say, I understand this. This is the troubling part. Delhi High Court. Fee structure is subject to change from time to time as per government decision. But this is a very general sentence which is incorporated, by which we are informed that the fee structure that is there, that structure can be changed. But what is
this fee structure?
Yes, our fee structure, correct. Of course, because our fee structure is not only ours, it is for everyone. This is one structure. Now, what, my lord, I am, my lord, trying to interpret possibility. Structure is 174 for all. So that structure can be changed as per the government notification. Agreed. But whether that structure post admission, whether can be changed, to that effect, I have only 2 points. Because on my against is, yes, you have seen that. Now that act of seeing of this sentence of change, of course, that is there because they can always change.
It's in bold letters.
It's a bold
so
letter.
You could not have missed it.
No,
Not,
I've
not is
no,
fine print.
I don't take that. I say that they have every right to change it. But their right to change, does it mean also to everyone? Whether every right to change also means to everyone?
Has to be, otherwise Article 14 will be hit.
Now,
others will come and say, why me?
Then, my lord, no, it is that.
And there are always special provisions for economically.
No, that is
those are there.
That's a separate. That's a separate thing. That's a separate thing. I say that. Then admission, my lord, admission and thereby consequent the transparency.
That admission is qualified by this. That admission, the fee structure at the time of admission is qualified by this. That is your difficulty. Not that it's a separate document which is coming later. Your admission is subject to this.
I was trying to interpret in this way that 7-7, according to your lordship's prima facie view, that it is entirely within the domain of intimation alone. Now, I am trying to say, my lord, this way, that 7-7, yes, it is within the domain of intimation, but the domain of intimation shows what is the ceiling of that domain and how that is attached to. Now, here, my lord, this is attached to for which admission shall be made. Yes, it is, I take it is intimation. So, therefore, prior to October, there was also an intimation by them for which there was a fee structure on which basis 74 came up. So, I say that 7-7 gives a clear idea. Yes, it is for intimation, that it is for the entire course. Now, this entire course, my lord, that gets completely broken if in the midst it is enhanced based on that bold portion, 75. And for which admission shall be made. So, therefore, it is not just an intimation, it is also relatable to something which they will do. And my lord, this restraint part, kindly look at this part, that the total fee shall be divided into the number of years. So, this is again transparency table, or as the case may be, the number of semester. In the first instance, fees only for the first year of semester shall be collected. Now, this part, well, this has got nothing to do with intimations. Kindly read this part. In the first instance, fees only for the first year of semester shall be collected. So therefore, there is a table. It's not a mere table alone, a table for taking admission. And further, 7-7 gives the restrictions that you cannot ask for the entire money of the table. So, putting these 2 points together, my respectful submission before your lordship would be that 7-7 entire domain is not intimation. 7-7 is mandatory regulations of do's and don'ts. So far and do's, that is the first part which they have to do. And so far as don'ts, that is, my lord, they cannot, that in the first instance, fees only for the first year of semester. Now, if that's page 75, my lord, they are right, that bold portion, if overrides these.
Does not override this. They, in the affidavit in opposition, in the writ petition, they have shown that they were called even after the intimation on June 6th.
Yes.
So that is prior to July.
Yes.
So that this was covered. They had complied with this. That was before the writ court.
But then, my lord, the words for which admission shall be made, then some.
This is the next
purpose.
Purpose, yes.
Purpose.
Everything qualifies intimation.
Yes.
Intimation to a competent authority shall send intimation in advance the fees chargeable for the entire course. So that intimation contains the entire fees chargeable for the entire course, and everything else entire comes in.
Yes.
And total fee shall be divided in the number of years. There should be a transparency and breakup in that.
Yes.
That obviously refers to the intimation.
In that way, two possible interpretations. One may be a lesser one. Another, on one hand, there is, even in the intimations, there is for admissions, and also in the notifications, the decision itself also for to be admitted. So both have to, my lord, have to be ignored, that it has something to do.
No, two are on separate footings, Mr. Dhar. We are treating these to be different. First, we have to see 7-7. 7-7 we have to read without any subsequent thing. Because subsequent act of the executive cannot give a meaning to the statute.
Well, 7-7.
7-7 we have to see first.
Yes.
Independently.
Yes.
There is no ambiguity so that we can give a purposive interpretation to this. If there was some ambiguity, could have.
Yes.
But it is very clear, a professional college shall send intimation to a competent authority in advance. What? The fee is chargeable for the entire course commencing from the academic year for which admission shall be made. The total fees shall be divided such and such. First instance only one semester, and then fee chargeable by professional shall be subject to that ceiling.
Yes.
But this is the entire provision. We find no ambiguity in it for us to introduce our own opinion by way of purposive interpretation.
Well,
This is not a fetter to this. Your best case probably in the light of this observation is in the notification itself. We have to interpret the notification otherwise. Whether we can reconcile, if we reconcile, how can it be harmonized? The two things in your favor are the to be admitted and from date of effect from the date of this notification.
Yes, well, I say that.
And in their favor is 23-24. It again comes back to that.
My submission is this, that it supersedes on 16th, not before 16th.
But for what? Which period?
So that from 16th, a new structure comes, which would be applicable for whoever would be admitted after 16th. Because it will continue for several years, minimum 4 years. And it might be continue for 7 years. It comes on 16th.
That is why we asked you a question that whether there can be a mid-session admission. If there cannot be, then it has to pertain to your batch. Took admission in 23-24.
Well, 74, the admission is only at the beginning. So that's
it applies to that only. From the date of this.
I say that because this is not the only notification.
So there was
there was the previous notification.
They were being governed by that, which has been superseded from this date.
Yes, that's I'm saying that prior to 74, there was an 18 notifications. The result of the 18 notification was the table of 74. Now, one day that ceases to exist. 16th of October. Prior to that, our admission is over. Now, whether, well, this I had, these are my
we have to interpret it. So it boils down to that notification itself.
Yes, it does.
I'm grateful.
Why?
I'm recalling my once.
In view of the issues involved in the appeal as well as the interlocutory application being identical, we take up the appeal itself for hearing along with the application. Full stop. Heard learned counsel for the parties. Full stop. Hearing is concluded. The matter is reserved for judgment. Full stop. We'll try to be as fast as possible. In the meantime, we'll stay the operation. Otherwise, there'll be no meaning to this if they're not permitted to sit in the examinations. But this will be subject. We'll make it very.
Yes, it has comments, but there are.
Examination is there.
Well, it started on 13th. It will continue up
Whatever
to
is
25th.
still remains. Whatever still remains.
From 13th onward, it is going on.
The operation of the impugned judgment as well as the impugned notification dated October 16, 2023, bearing number 466-cap E small dn edin hyphen within bracket capital T stroke 10 capital M hyphen 04 stroke 2004 within bracket part Roman 4 shall remain state till disposal of the present appeal. Full stop. Next para. It is made clear that the writ petitioners, that the appellants in all the matters shall be permitted to take their examinations in the interregnum, which will be subject to the outcome of the present appeals. To take their examination and course sessions subject to the outcome of the which will be subject to the outcome of the
Subject to availability and feasibility, because the question already the course
Feasibility is they are not issuing the admit card because I have not been able to pay the money. They have not issued the admit card. That is the only feasibility.
To get them admission in the examination. So that is a paraphernalia I am to follow.
If you say subject to feasibility, then we can't haul you up in contempt. Subject to feasibility, we are leaving it on you.
Afraid of the contempt petition at this
it has to be registered.
No, Mr. That is just.
Given manner, Mr. Lordship has paid the notification, manner, there should not be any consequence of
returning the money to those who have already paid.
That
No,
order.
if they win the appeal, then only.
That only, that is
No, we have stayed operation. This is staying operation does not set aside the notification.
consequence of the same manner. Should no benefit out of the same stay manner should.
No, no, how can it be? Definitely not. Staying, it's settled.
Notifications. All the colleges would be affected.
Acha,
Judgment.
stay of the operation of the notification, insofar as the appellants herein are concerned. Stay will be only insofar as they are concerned. If we allow the challenge, then everything goes.
Well, university, the admission subject to correction, university has to be, because admit card is issued by university, as per my knowledge is. Because the college, university courses, admit
They
card.
all are respondents. Sir.
So, university.
Conducted by Macau.
Macau. So, when university, there has to be direction to the university.
University is a party.
Yes. Yes.
It is made clear that for the purpose of implementation of the above direction, comma, what is the respondent number of the university?
No, এটা তো কম আছে।
7, my lord.
7, 8, 9.
The respondent number 7 to 9 shall act on the communication of the learned advocate for the appellant and serve a copy of this order and shall ensure that admit cards shall be issued provisionally to the appellants for the purpose of enabling them to appear in the ongoing examinations. Thank you.
Hello, obliged.
Huge.
Your Lordship, may I have the copy of the opposition? Opposition
They
regarding.
have not returned it to you.
No, Your Lordship, is there with me? Gratefully, Your Lordship.
Can you furnish a copy of that later on?
Yes, Your Lordship.
Do it during the course of that, it will help us.
Lordship.
And you please just mark those 2 pages which you were cited, 72 and 90.
Lordship.
Just put a tag. We'll forget later on.
Will do it. Will do it.
Not today. Not today.
Yes, my lord. Item number.
Not today. Not today. No, appellant. If you want to move the matter, we'll hear the matter. Appellant.
Only.
There's a caveat.
Yes, my lord, there is a caveat.
Not in this matter. Is there a caveat?
Caveat.
Then, Mr.
Only that it will be possible to take next Monday. I have some personal difficulties in.
আচ্ছা ফের একটা order record করো. Learned counsel for the appellant submits. Now, although the appellant is present, comma, none appears for the caveator respondents. Full stop. Learned counsel for the appellant submits that he is in some difficulty if the matter is not taken up today. Full stop. Accordingly, let the matter stand adjourned till March 23, 2026.
Deep 9.
Item 10, my lord. First time I am entering appearance for respondent number 1 to 5, my lord.
They are not there. We are making it not today. You don't have a right of hearing in order for 2.
My lord, may I pray for some time, my lord, in this matter? First time appearing, my lord.
First time, so what? You don't have a right of hearing the respondent in order for
Please to
2.
direct them to serve copy upon me, my lord.
No. You have to write a letter to them. You know the procedure. Yes.
11, 12,
Stop not.
13, 14, 15 to 16, 17, 18.
Yes, ma'am.
There is any caveat?
No.
Yes, there.
Lord, I am for the appellant, my lord. This is appearing for the first time. There is no caveat, my lord. We have
We'll take it up.
attended
What is the defect where?
my lord.
Defect has been rectified. my lord.
Removed.
Yep.
So we'll just check up this. Right. Thank you. Yes.
My lord, assailing the order dated 30th August 2025, lord,
Yeah.
whereby the my lord, the learned trial court refused our ad interim prayer. This suit is for my lord defamation and damages.
Sorry, defamation and?
Defamation and damages, my lord, as well as permanent injunction restricting the respondent not to, my lord, further post any defamatory materials. That was the main prayer, my lord. And if your lordship may kindly seize the impugned order, my lord, the learned court below, my lord, observed that the last post was of July 2024, which is not, my lord, from July 2025 our cause of action arose. My lord, what happened, my lord? The appellant number 1 is the mother-in-law, the appellant number 2 is the husband.
That we have seen. Yes.
My lord, the respondent is the wife.
There's a divorce suit between you.
My lord, as of
now, no.
nothing. My lord,
you are sure you are not making out a ground for a divorce?
Not yet, my lord.
Let us see the impugned order first, then we'll just because it's a short order.
1-page order, my lord, kindly see.
That is the only ground probably on which ad interim has been used.
Yes. And my lord, we have made out a case that the cause of action arose
Which was that paragraph
Yes.
of your either plaint or injunction of the trial. Let us see the plaint.
My lord.
Page 18.
My lord.
14, sorry. Yes, yes.
Well,
There are
kind-
continuing cause of action.
From 7,
Para
para
18.
7 onwards.
Para 18.
Yes, yes.
And have you annexed any of the posts?
My lord, all the posts. My lord, pre-July
Who
2025.
was the worst ones against you?
My lord, the defamatory post starts from, my lord, page 58 onwards. Prior to that, my lord, 2021, she
Yes,
left USA, returned to Kolkata.
Leaving
My lord,
the specific
yes, the child remains with me in USA. The appellant number 2.
special child.
Special child. My lord, till 2025, she does not post anything. I mean, all the posts are, if your lordship may kindly sees, are happy posts. She is
With
shopping.
dress and with dress and well dressed and
And thereafter, my lord, she makes a demand. I refused. And then this started. So, my lord, we approached not only, but prior to that, we sent a legal notice. Thereafter, we approached the learned court. My lord, praying 2 things, my lord, at interim stage. 1, to remove. My lord, I understand. For removal part, the court needs to adjudicate. But my lord, restraining her from posting any further defamatory posts, my lord, that ought to have been considered. This is my lord.
I am in a reputed post.
Show us 1 or 2.
My lord, kindly see. My lord,
58 we have seen.
Yes. 58 onwards, 59.
These are the
Then
comments.
64.
59 onwards is the comments.
Comment. 64 is another post. 66. And your lordship will kindly consider that the picture of the child has been used.
Even আর একটা ইয়ে করেছে মকারি করেছে
72. And 83 onwards, my lord, these are all videos.
Where is the last post?
94.
My lord, last post 103, my lord, kindly sees. And thereafter, the last post is
স্যার আরেকটা দেখিয়ে দিন 94 94
They've not even spared your mother-in-law. Your mother.
Yes, my lord, one of my father-in-laws.
স্যার 94
হ্যাঁ
94
ঠিক আছে, ঠিক আছে।
94 টাকা mockery of myself.
Yes, last post at?
My lord, the Page number is 12th August 10. Well, page number 116 is our last annexure. And 94, my lord, kindly considers this is, my lord, extremely defamatory.
Mockery of myself.
Page 94, my lord.
Page 90. I'm in a reputed post at AI.
This is your picture morphed.
Yes, my lord.
Shiva.
Page 94?
94.
Yes.
That is your
Appellant
picture.
Appellant number 2.
Appellant number 2? No,
Yes.
no. He has mustache, shaven mustache. What did you say, appellant number 2?
My lord, appellant number 2.
Or 2 is the husband.
To the husband. In 112, my lord, your lordship will find August 12, 2025. 112.
He filed the suit when?
So, the only ground for rejection of the ad interim prayer was that, my lord.
When did you file the appeal, Mr.
My lord, appeal, 13, appeal.
Appeal, this appeal.
This appeal was filed.
13th of August.
9 days delay. 9
Let's
days
just check
delay.
up from the
Section 5.
13th August. Yes.
There is a section 5
Quite-
application for 9 days delay. My lord, 6th of November 2025.
9 days delay আছে ওটা বলে দিন। তাহলে
There's a
can
delay.
contempt.
Delay of 9 days. My lord, there is a CAN application.
Then you have to serve on the other side and come back. Then there is no scope of passing an interim order.
It was an
Section 5
interim extension. Interim extension.
Yes, section 5 is there. The appellant shall serve copies of CAN 1 of 2005, CAN 2 of 2005, as well as the memorandum of the appeal on the respondent indicating that the matter shall be listed under the same heading. How soon can you serve?
My lord,
Where does she reside? Barashat. We'll keep it after 2 weeks. Shall next be listed on March 23, 2026, when an affidavit of service to that effect shall be filed by the appellants.
Right.
Let's come back on that date.
My lord.
If you could wait for 90 days to expire, we could have directed the appeal, the injunction to be heard out. But we don't know whether you have served a copy of the injunction on the other side. That's the practice in our courts not to serve. In any event, I mean, you should have served a copy. By now, the injunction would be over probably. Anyway, let us come. Yes.
19 minute, I am for the respondents.
Now
for the appellant in this matter, my lord.
Section 5 is there.
Section 5 is there, my lord.
What is the delay?
The delay is a long delay, my lord. Unfortunately, my lord, it's a 5 years delay. I mean, injunction, my lord, I say, my lord, I'm only on the merit
You
of
have
the
challenge on injunction.
Injunction, ex-party injunction allowed in the year 2020. My lord, I have come.
That delay itself defeats equity.
My lord,
on merits also, delay defeats equity.
No, my lord, only
if you
one
could
thing.
wait for 5 years.
No, my lord, there is one development that has come up in the year 2025, my lord. I say, why say, my lord? The respondent, my lord, this who happened to be the defendant number 29, she made an application before the trial court to cultivate the unpartitioned land. That application was allowed by the trial court. I preferred a revisional application before the honorable court, my lord. That order was set aside on the ground that since it is an unpartitioned land, my lord, that order cannot be passed, my lord. Now the injunction is, my lord, injunction was, my lord, was given, my lord, restraining the defendants, the appellants, not to disturb her from cultivating the land, my lord, unpartitioned land. That was the, my lord, injunction. An injunction, my lord, was given to the defendant number 29, my lord, who happens to be the respondent over here, my lord. She claimed that she was not in possession. I am in possession of the land. In spite of that, ex parte injunction was allowed, granting her the liberty, granting her the order.
Your rejection of her, allowing of your revisional application cannot give a ground post
But that
facto
is,
to challenge
but
the.
kindly the ex parte kindly see the ex parte order. In what manner with the application?
This was an ex parte order.
Ex parte injunction, my lord, that was allowed.
It would appear what could be done. This is the disposal of the application.
What was the prayer and what was the order, my lord, granted, my lord?
Shows.
My lord, kindly, my lord.
My lord, kindly see the section 5 application for.
Lord, we have come to know.
No explanation about the 5 years.
And we have come to learn, my lord, once this application was rejected, my lord, by the.
Let us see the section 5.
Yes, kindly.
We have
My lord,
nothing.
2-page application, no prayers, nothing.
We have come to learn about this injunction, ex parte injunction only, my lord, recently when all of a sudden this application was rejected by the honorable court.
It's a statement in the
My lord,
section.
my lord.
Just by
That is
stating that there is no gross negligence or there is
My lord,
delay
section,
or
my
lack
lord,
of
no, my lord.
delay cannot
Get
be
your
called.
point. Let him.
Yes.
My lord. My lord, this is, my lord,
Sorry. No, sir. Yes.
paragraph 5, my lord. Paragraph 5 of my application, my lord. My lord. All along this ex parte order was suppressed. I was not aware of this ex parte order.
You
Now,
did
when
not file any written objection to the temporary injunction application?
no, nothing.
You had not appeared in the suit.
I appeared in the suit, but when this
It was your duty to.
there were two injunction applications, my lord. One injunction application was filed by the defendant number 2, seeking restraining order against the appellants not to make any construction of the scheduled property, suit property.
You are represented by an advocate.
Lord, I can understand.
So
But
you
I have,
obviously
my lord, in this case, my lord, I
There's
will
no grounds, maybe
candidly admit, my lord, it is something which I should have contested the application. Well, unfortunately, when I am in possession of the land, when I am cultivating, it is admitted by the defendant number 29.
Look at the
In
merits
spite
now.
of that,
Nowadays, we cannot look into the merits unless the section 5 hurdle is over.
my lord, I
Even
can understand.
incidentally, we cannot
My
see.
lord, I can understand, my lord, but this is a case, my lord, where
At the stage of the suit, you fight out the suit. You have filed a written
no,
suit.
but the thing is that, my lord, after rejection of the cultivation application for which was rejected by the honorable court, now they are coming with this order
You have
to
not
my
even
land.
disclosed about the revisional application.
Yes, I have.
Clearly, I mean, nothing annexed.
My lord, it's annexed with my stay application, my lord. It's not with this section 5, but it has been annexed with my stay application.
The difficulties we are telling you. You have stated in para 4 that you came to learn that an order restraining them from 2011, 2025, you came to learn.
My lord.
But you have not explained what prevented you from learning it because you had appeared in the trial.
No, because they tried
you
to
have
enter
not
my land.
disclosed that actually.
Well, when they tried to enter my land, and they came up with this application that I have this order. Now you have to allow me to enter the land. Then only I have come to learn this application.
That is different. But we might have learned from there, but you have not explained. First of all, you have not stated whether you appeared in the suit.
My written statement is there, my lord. I have appeared.
No, in this section 5, you have
section 5 application. I have not stated.
So that they may argue it's a suppression. It's a material fact.
But in my stay application, my lord, I have
stay application. You cannot look into.
But
pleading has to be there.
Pleading has to be there, my lord.
Section 5, there is a suppression of your having entered because if you say for the first time you came to learn from something else, then you have to state at least before the court. You have to come with clean hands. You have to say that I entered appearance. And you have to explain what prevented you from entering appearance till date.
But the drafting, my lord, if I go through the drafting, my lord,
if it was better drafted, it would be worse for you. You had to explain then.
My lord, I have to explain that.
Don't find any explanation.
My lord, only one thing, my lord, has to take into consideration, my lord, this application, injunction application, passed ex parte.
Now trying to regularize the divisional court's order.
But passed in spite of the fact, my lord, that she has herself admitted that she is not in possession. I was cultivating the land, and in spite of that, my lord, the injunction application was allowed and restraining me from not to disturb him from cultivating the land.
Merits in the case. There is no explanation here. You have not explained what prevented you from.
But that was not within my knowledge, my lord. This order was not within.
That is not an explanation at all.
But that is the my lord. That is
entered appearance in the suit. You cannot play ostrich. Put your head into the sand and say, I don't have knowledge.
My lord, this is a
it was your negligence then. It's gross negligence.
I cannot, my lord. I cannot, my lord, say that this was the fault of the advocate who did not inform me.
You have to reject it on the ground of, because then you have to state that I entered appearance. For this reason, I did not know in the interregnum. We cannot accept this contention.
My lord, then my lord, kindly give me liberty to my lord, file supplementary
What
affidavit.
will you do right in that?
My lord,
We are wondering
kindly,
that.
let me try my luck, my lord.
My lord, from
Kindly let me let my luck.
20
Because
till-
this is something, my lord, which
You
is
go on cultivating, let them file a supplementary affidavit.
My lord, it is-
my lord, because
Learned counsel for the respondent rightly for the defendant number. You are for all the respondents.
no, my lord, I'm not for the. Oh no, sorry, my lord, I'm
32 to 34.
Yes,
You are supporting him or him?
I'm supporting him. Though I'm
Separate.
defendant, my lord, he's a plaintiff, but I'm he's representing the
No,
plaintiff.
he is also defendant.
Yes.
Oh,
My lord, I am
Whom you are supporting, Mr. Ahmed or him?
I'm supporting him. Obviously, my lord,
He is for the defendant. Which defendant?
Because
That is
there
the
are
question.
many of them, my lord. So I have filed wakalatnama accordingly. But I am representing 1 to 11, 13 and 14. Yes, yes, my lord.
1 to 11, 13, 14.
Respondents, plaintiff, opposite parties. 1 to 11 and 13 and 14.
Plaintiff's opposite parties. It was their suit.
That is which is mentioned. What it is mentioned
we are one of the we are the plaintiffs. My lord. The injunction has been obtained by defendant
You have
number
described
29.
them as plaintiffs also.
My lord, who?
You in your section 5, see the caption
Yes.
of the causal, page 10.
That is
No, my lord.
what I have seen, so I have mentioned.
No, my lord, kindly see.
Please come to page 10 of your section 5. After number 34, how have you captioned it?
Section 5.
Respondent, plaintiffs, opposite parties. Oh.
And you have claimed yourself to be defendants.
yes, some of the defendants.
No, some of the defendants. My lord, some of the
right, you are
defendants.
right. You are right. No, sorry, no. Yes, you have described yourself to be defendants.
Defendants, my lord. I'm defendant. Defendant number 6, 7, 8, 9, 15, 16, 17, and 18. They have been restrained, my lord. We have been
sorry,
restrained.
you have suffered. Yes,
Yes.
You're right.
And
you are for some of the defendants.
Defendant 32, 33, and 34.
And Miss my lord, defend this respondent.
You should correct the caption also. You should correct the caption also.
Well, I shall, my lord, see.
Learned counsel appearing. You on a slip of paper, you write the respondent numbers at least correctly, so that they can take. Learned counsel appearing for some of the respondents controverts the condonation application and points out that it has not been disclosed in the said application that the appellants entered appearance in the suit much prior to the alleged date of first knowledge of the impugned order, as well as that the condonation application is devoid of any reason as to why the appellants in spite of due diligence, could not have knowledge of the impugned order during the entire period from entering appearance in the suit till the filing of the appeal. Next para, we find substance, prima facie, we find substance in such contention, however, at this, learned counsel for the appellant seeks liberty to file a supplementary affidavit for the purpose of furnishing further particulars, for the ends of justice, we permit the appellants to file a supplementary affidavit within a week from date. Next para, an advance copy thereof shall be served on the learned advocate for the appearing respondents.
My lord, one request, my lord, week, my lord, Eid is intervening.
Oh,
my lord. Can it?
How long, say?
2 weeks, my lord.
See, we can come to 3 weeks also. You're
2 weeks is enough.
1 week na karo within a fortnight.
Within a fortnight.
So next para, but you have to serve on the other.
I believe, my lord, all
not
of the
all. Other plaintiffs are there. 12 is not there. Yes. The an advance copy of the supplementary affidavit shall be served on all the respondents. Copies of the you are served with copies.
Yes, my lord. Only the section 5 application.
I am also served with only the section.
You had lodged a caveat.
No. I was only served.
There was a direction previously of served.
No, my lord, my junior has served it better. It's better, my lord.
Appearing
It's better, my lord.
The appellant shall also serve copies of the condonation application on the non-appearing respondents and file an affidavit of service to that effect on the returnable date. The matter shall next be listed under the same heading on March 30, 2026. No, sorry, not March 30. On April 7, 2026. 7th.
I'm grateful.
Affidavit in opposition to be filed to the supplementary and to the
Affidavits in opposition to the condonation application shall be exchanged in the meantime.
If your lordship goes through the Lord injunction application, your lordship will see
We cannot
the
touch
kind of
that without
prayer
your
that has been made and that kind of prayer that has been allowed by the trial court, my lord.
Even if we are convinced on that, Mr. Ahmed, we cannot look into that if the Section 5 cannot
Something
cross
needs
the
to be
hurdle.
done, my lord. If something wrong has been done, and unfortunately
Now
that
we
has
cannot.
not been challenged, my lord, it needs to be, my lord, corrected.
Supreme Court judgments are there, you bring the judgments on
My lord, it might be the judgment of your lordship, my lord.
I need not point it out to your lordship, but your lordship is aware of
No,
that.
but point out because we have to deal with this.
Very well.
Because Mr. Ahmed is specifically rely on the infirmity of the order.
He's more on merit.
Previously, that the position was that one of the considerations could be that
Could be
the merits of the case.
Yes.
Now probably that has been made more rigorous.
Yes,
So you have to bring out one or two judgments, and if you can give advance notice to Mr. Ahmed so that he can also come prepared on those judgments.
Very well. I mean, citation more. They can.
My lord, I'm grateful, lord. Thank you.
I'll hand over a copy to you. Very good. I'm so grateful.
Thank you.
Not
Twenty-one.
Saifur Rahman
Same.
It's 21.
You are appearing.
Yes, that.
Is there any caveat?
No, my lord, this was your lordship had heard this, my lord. This is that roll on and balm matter, my lord.
Or the other side, unless they are
Should
there.
we come back at 2 o'clock, my lord?
You bring your other side also.
We'll give a notice.
We'll give a notice.
Very well. তাহলে এখন ছেড়ে দিন আর থাকতে না, we'll call from this matter.
Great.
এই ফাইলটা বার করে রেখে দেবেন। আমাকে পাঠিয়ে দিন। কেন স্টুডেন্ট গুলো তারা বুঝতে পারবে না। অ্যাডভার্টাইজমেন্টটা বন্ধ করে দিন। Yes.
My lord, Mr. My lord, that commercial speech impairment matter and my lord, the jurisdiction matter, my lord, on the.
But I had, my lord, I had inquired with my senior. He has left court because of resolution. I have intimated to my learned senior colleagues, my lord, that
Then today
that is the reason why we did not appear in the first call.
But
whatever you say, you can complete your argument or we can.
We were arguing.
my lord, we had completed our argument.
Oh,
My lord,
right.
they were arguing. I have to, my lord, rejoin. My lord, I have to rejoin. Then, my lord, only one request, my lord. I'm so sorry, my lord. I'm making.
Yes.
My lord, it was heard for quite some time back. So anyway, my lord, I'll have to, my lord, rejoin. I'm sure, but anyway, my lord, I'm sure, my lord, will recall. My lord, tomorrow I'm in some difficulty, my lord. I'm not here. So, my lord, Wednesday, my lord, if I may rejoin, or my lord, if it's taken up on Wednesday, whatever's convenient, my lord. I just don't want
Yes,
to.
yes. An adjournment
disrupt.
is sought on behalf of the
Well,
respondent. Yes.
For on
Because
because of the.
respondent number one. Which of next para, learned senior counsel appearing for the appellant apprises the court that he has some difficulty tomorrow. Footstep accordingly. Let the matter stand over till March 18, 2026. Good afternoon.
Grateful, my lord.
Let them show. Well,
22.
Not today.
grateful.
Then,
24.
not today.
26. 31.
Not today.
30. 33.
Same.
34. 35. 36. 37.
State.
38. 39.
Are there is a taken any matter in which both sides are willing to do the matter, or it's at the expert stage? Expert stage.
My lord, item number 64. Perhaps this is my lord, accident matter regarding railway tribunal. My lord,
You don't have determination.
kindly.
So why is it appearing before us? You mentioned it?
No, madam. I have not mentioned.
64.
Yes.
What other matter?
Another matter is
106.
106.
64 or 106 are लिखे नहीं?
106, my lord. This
You want to do the matter?
Yes.
These two matter. Any other matter where both sides want to?
Lordship, item number 42, Lordship. I'm appearing for the petitioner, Lordship. I'm only making a small prayer, Lordship. All the respondent have been served except for the learned government pleader's office, Lordship. And they are saying since the matter is appearing before your Lordship, unless an order falls from your Lordship, they won't accept the service, Lordship. Item number 42, Lordship.
Well, Lisa call করে যান 42 পর্যন্ত call করুন।
41. 42.
Lordship.
My lord, I'm for the petitioner. We only seek directions to file through the GP.
On the prayer of
Just
learned
to serve at the
on the
GP.
prayer of learned counsel appearing for the petitioner, comma, the petitioner is directed to serve a copy of the writ petition on the office of the learned government pleader on behalf of the government pleader on behalf of the state and file a receipt in that regard on the returnable date. First of let the matter stand over for the day.
Much
Great, Lordship.
আচ্ছা 60 আচ্ছা কল করে যান দেখি
43. 44. 45. 46. 47.
64 এর ফাইলটা একজন দীপঙ্কর বার করে রাখো।
49. 50. 51. 52.
আর 106 এর
53. 54. 55. 56 to 57. 58. 59 to 60. 61. 62. 63. 64.
জাস্ট চেক দ্য ফাইল আর 106টা বার করতে
My lord, it FMA 333/2000.
That is not 64. 64. এটা কি ফাইল দিলেন? আপনি তো এফএ নাম্বার দিয়েছেন একটা। কি দিচ্ছ ফাইল? মেবি রাইট। কিন্তু এফএমএ লিস্টে অ্যাপিয়ার করছে, এটা এফএটি তো আমার ঘরে রয়েছে। আরে কজ লিস্টে ভুল হয়েছে, আপনি ঠিক করে নিয়ে করে দেবেন এটা। এর ফাইলটাও ইচ্ছে তো দেখছি, কম্পোজিশনের যে নামটা দেখাচ্ছে।
ভুল করে
কালকে কারেক্ট করে দেবেন। উই আর নট কলিং দি ম্যাটার ফর্মালি, ইট ইজ মেড নট টুডে। থ্যাংক ইউ। দেখে এটা করে দেবেন, ঠিক ফাইলটা এটা লিস্টে যেন ঠিকঠাক অ্যাপিয়ার করে। আর ওর যদি ফাইল এসে থাকে এফএমএ, তাহলে পাঠিয়ে দেবেন। কল করুন থাকে।
66, 67, 68, 69 to 73, 74, 75, 76, 77, 78, 79, 80, 81, 82,
82, my lord.
83.
82, my lord, I am for the appellant.
Is there any caveat?
My lord, no, there is
Other side is appearing.
other side is not appearing, my lord. There is
Just soft copy.
a soft
Was there a direction?
direction. My lord.
Then we won't take up today because not today.
83, 84, 85, 86.
Only both sides are present, or it is appearing for the first time without a caveat. Call.
87,
106 ফাইলটা বলবো।
90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106.
Lordship. My lord, may I submit?
1 second. Yes.
My lord, this appeal has been arising out of a judgment and degree passed in a partition suit. My lord, together with judgment and degree, I also challenge one interlocutory order just 2 days back, where my witness has been closed by the learned trial court. My lord, on 15
This is against preliminary degree.
Preliminary degree. My lord, on 15, my lord, on 2 occasions, I have not been able to give the evidence. My evidence has been closed on 15/12/2025. My lord, argument was fixed for the case on 17th. My lord, on the same date, my lord, degree was passed. Hurriedly, lordship. And my specific case is that, my lord, from a common owner, I and the plaintiff, I am the defendant in the suit, I and the plaintiff both purchased the property. Demarcated portion I have purchased. So my specific pleading that when demarcated portion has been purchased, my lord, no partition suit can be live.
The present appeal has been preferred against an order, against a preliminary decree of partition. Push-up, learned counsel for the
as well as, my lord, interlocutory order.
Defendant appellant submits. Interlocutory order cannot be changed directly, we'll say. Learned counsel appearing for the defendant stroke appellant submits that the specific plea taken by the appellant before the learned trial judge was that the plaintiff stroke respondent and the appellant purchase the subject property in separate demarcated portions and as such no partition suit lies. Full stop. Next para, that apart it is argued that by, what is the order number?
My lord, order number 26 dated 15/12/2025.
Where is that annexed?
My lord, it is on memorandum of order.
Order number 26.
Yes, lordship.
It is further submitted that video order number 26 dated December 15, 2025, the evidence of the defendant stroke appellant, as DW was closed by the learned trial judge. Moreover, although the next date, that is December 17, 2025, was fixed for arguments of the parties, the judgment, the impugned judgment and decree were passed on the self-same date. Pushed up. Next para. The appellant has also set up the alleged error stroke irregularity in the said order dated December 15, 2025 as a ground in the present appeal within the contemplation of section 105 of the Code of Civil Procedure. Next para, in view of a prima facie case for hearing of the appeal on merits having been made out, the operation of the impugned judgment and decree dated December 17, 2025 is stayed till disposal of the application. Next para, the parties shall remain restrained by an order of injunction from selling, transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property, also till disposal of the application. Both parties shall also maintain status quo as regards possession of the suit property till disposal of the application. The appellant shall serve a copy of Can
1 and 2, lords.
Copies of Can 1 of 2026 and Can 2 of 2026 on the respondent and file an affidavit of service to that effect on the returnable date. Next para, the applications shall next be listed for hearing on March 30, 2026 under the appropriate hearing.
Get full, lords.
Any other matter in which both sides are present or ex parte is to be moved? You want to move any matter?
Lords, I want to mention.
Mentioning, this is not the mentioning hour.
Lords, my item number is 113.
Achha.
I am traveling from Delhi.
Oh.
My request is that if Lords may fix any day for hearing of that.
Well, let us serially call it, or when it
Lords.
comes. 130 to file ta bar kore nite hobe. Ei je Anindita, 130 file ta bar. Your item is 130, 130.
113.
Oh, sorry, 113. 113 file ta bar. Yes. Tumi call kore. Update call.
103, 108, 109, 110, 111, 112, 113.
Give us half a minute so that the file comes. You are appearing for the respondent.
I am appearing for the respondent. Lords,
what do you want, please?
Lords, my humble request is that if Lords may keep this matter in third week of April, if possible, because I need to travel from Delhi. My client and me both are from Delhi. In the meantime, I will file my wakalatnama and reply.
Did you direct affidavits in the matter? If you want to use an affidavit in opposition, we'll also permit that in the meantime.
Lords.
Would you like to use an affidavit in opposition to this scan?
Yes, yes, Lords of the
So we'll give you that liberty also in the meantime, since you are fixing it on third week, you are saying.
Lords.
Very well. None appears for the appellant at the time of call. Full of learned counsel for the respondent submits that he is traveling from Delhi, and as such prays that the matter be fixed next sometime in the third week of April 2026. For the next para, what date will suit it? Third week means 20th to 24th to 23rd. 24th we take up single matters.
Lords, 23rd is okay.
23rd. 23rd, sorry, 23rd is a appeal hearing day. So between 20 and 22nd.
22nd, Lords.
22nd. Accordingly, let the matter stand over till April 22, 2026, when it will be listed under the same heading, full stop. Affidavit in opposition, if any, shall be filed by the respondent within. How soon can you do it?
We can file it by next week, Your Lordship.
You have to do that. We are giving you time for that. Leave is granted to the learned advocate having instruction to appear for the respondent to file wakalatnama on behalf of his client by March 27, 2026. 27. Thank you. Give your names, both of your names.
Milord, may I make one indulgence?
Yes.
Milord, item number 40, Milord. Milord, it is with regard to Milord expeditious disposal, Milord. Milord, Lordship may kindly.
What you have called and passed over. If somebody was watching, that's a difficulty. We cannot go back in time and call it again.
Milord, only,
Whenever you reach it tomorrow,
only difficulty is that Milord, the next date before the Lana tribunal, Milord, is on
you should have been present here when we called it.
Yes.
We have called it and made it not today. Not that we did not call it.
Milord, can it be taken up tomorrow, Milord, subject to your.
Tomorrow it will appear in the list.
Oh.
We have only made not today.
Okay.
We take up the applications also tomorrow. Calcutta application. Tomorrow probably we'll taking up applications before the order for 10 matters also.
Very well.
So you just keep a watch tomorrow. It will appear in the list.
Grateful, Milord. Sorry, Milord, for trouble.
No question of sorry. So no one else want to move any expertise.
Your Lordship, item number 116, Your Lordship. 16 and
Achha,
17.
let it be called on 116 about. Aste. So to file about korbe.
In Lordship, I am for the applicant, Lordship. This is my contempt application, Lordship. Appear for the first time, Lordship.
Then we will look into the file. 115 and 116 the two. Anyone else want to do any matter? Give the item number. You want to do any matter?
Yes.
With you. Very well. So you have to find out the files because these are down below in the list. 115, 116. What is the nature of contempt?
Lordship, the order has been passed on 2017's order, Lordship. Lordship kindly takes up page 190 of the stay application, Lordship.
Second judge, copy it down. Sorry, 190?
190, Lordship.
The previous contempt was dismissed.
Lordship kindly takes up the.
There's a further contempt after that.
Lordship kindly takes up the page 191, Lordship.
Yes.
Paragraph 5 onwards,
Five.
Lordship.
You have modified the order.
Lordship. Therefore, we have taken up the new application, contempt application.
Oh, wait a minute.
Paragraph 8.
What was the modified judgment? Where is that? Let us see the modification.
Lordship. . Lordship,
Modified.
page 172.
Only the service book recording of the punishment was
Lordship.
deleted. The rest
Lordship.
remained. They
Remain.
have not yet complied.
No, Lordship.
A prima facie.
Lordship, I am appearing for the.
I'm led by
for
Mrs.
the- Lordship, I'm appearing for the
Same
petitioners, your
petitioner.
Lordship.
Very
Yes, your Lordship, in this contempt matter, your Lordship has been pleased to, Lordship, there was an appeal which was
well. We have
pending,
been
your
apprised.
Lordship.
We are directing you to soft copy. We have been apprised.
Lordship.
Uh,
Lordship, there was it has merged. Pursuant to your Lordship's
prima
order, it
facie,
has merged.
we find prima facie that a case of contempt has been made out inasmuch as the initial order was modified by a subsequent order dated November 27, 2025, only insofar as the portion of the impugned judgment which directed the service copy of the concerned BL and LRO to record the punishment meted out to her was set aside. Full stop. However, the rest of the order was sustained. Full stop. It is alleged in the present contempt application that despite the same the alleged contemptor has deliberately flouted the order as modified. Full stop. Accordingly, the petitioners shall serve copies of the contempt application.
Lordship.
All are contemners. Yes, on the alleged contemners, indicating that the application shall next be listed on March 30, 2026, when an affidavit of service to that effect shall be filed by the petitioners. Thank you.
Grateful, Lordship.
Grateful, my lord.
Thank you.
Grateful.
116 out of 10.
Your Lordship, this is my application, Your Lordship.
Appearing for the first time.
Yes, Your Lordship.
What is the matter?
Your Lordship, have passed the order judgment on 2nd December 2025.
This is also contempt.
Yes, Your Lordship, both. Until date, Your Lordship, we have communicated twice. Means once we have communicated the judgment, and on 19th December, we have communicated to comply the judgment of Your Lordship. Till date, no step have
They
been
have
taken.
not proceeded on the basis of the vacancy notification.
Nothing, Your Lordship.
Why
Till
two contempt applications?
two match suit was there.
Since a prima facie case of violation of the judgment dated December 2, 2025, the date was the same in both the matters.
Yes,
Both the
Your-
orders.
yes, Lord.
December 2, 2025 has been made out, the petitioner shall serve copies of the contempt applications on the alleged contemners, indicating that the contempt applications shall next be listed together for hearing on March 30, 2026, when an affidavit of service to that effect shall be filed by the petitioners.
Grateful. Much obliged.
You are the only person available, so no other matter. Okay. There are two contempt applications. দুটো তো 16 আর 17 তাহলে একটাই contempt.
একটাই। I tender my apology, Your Lordship.
ওটা সিঙ্গুলার নাম্বার হয়ে যাবে সব। হ্যাঁ ঠিক আছে দেখেন যা ডাক্তার কেউ নেই ফাঁকা করে ডেকে ফাইলটা পাঠিয়ে দেবেন ওই তন্ময়টা ইমিডিয়েটলি ওটা এখন লিখতেছি